Submission, my lord. Moving a memo, my lord. No interim maintenance from past 5 years.
Yesterday the matters have come.
Yes, my
Why
lord.
were you
I
not
sought
there?
for 3 p.m. when it
How
was,
can the court grant you at your convenience?
my lord, because
You have
it
to
was
come when the matters
in
are
front
listed.
of in charge court. I made a submission.
How can you make a submission at 3 o'clock? Why should
Had
it be?
exam, I asked for another date. Then the in charge Saibiru told that because the other party was by that time they have gone. So told then in the order sheet
See
also.
the list, you will see the cause list from the net.
Yes,
There it is not mentioned as 3 p.m. It is there in the usual course.
in the order sheet it was mentioned.
Not on the order sheet, in the cause list. You have to look at the cause list.
Yes, my lord, but I had an exam, my lord. I'm studying law, my lord. So as soon as I finished the exam, I ran and came here, my lord.
Why should you run and come? You can take it some other day.
Yes,
This is matter on Monday,
Monday exam, my lord. Tuesday, my lord.
Tuesday.
Submission, madam, for being documented.
Yes.
We have filed an IA for the modification of the order dated 15/4/2025. We have filed an IA on 21/4/2025.
Who passed that order? Justice
Justice Pradeep Singh.
Yes. Now everybody in all the interim orders having taken it, I will not review it. Move before the very same court. Yes.
I seek an adjournment. List 1, serial number 11. I informed the other side also.
Let her call it, call on the.
List number 2
Yes.
for matters referring to Lok Adalat. List number 2.
Yes, matters are referred to Lok Adalat.
List number 1 for dismissal. Serial number 1.
Yes, ma'am. Serial number 1.
Chandrasekhar
For the
PM.
petitioner in this case, madam. I have applied for certified copy as to getting whatever the amount which paid by me myself, and we will get it and calculate it and file the memo of calculation before this honorable court in next day. So that
No, for that reason, you shouldn't appear before the court.
thing is, there was a miscalculation in attending the matters and all that.
2 times.
So that I am regularly practicing
Yes.
here only. Because of by miscalculation, it
Yes,
was
yes.
happened.
Lordship, the amount has been not fully deposited, Lordship. That's the instructions.
How much needs to be deposited?
Near about 3 lakhs.
So that we will apply for certified copy of the entire order sheet. It has been mentioned in the order sheet before the trial court. So that I will get the copy and make a calculation
For
and
that
file.
reason, you don't require this much
Lordship.
time.
Lordship,
But there is, please wait. Where is the interim order?
Interim order.
Interim order is dated 13/12/2021.
Yes, madam. After
Now,
that,
I'll list this matter next week. By that time, as per the order dated 13/12/2021, if the amounts are paid, it's fine. Or else the stay granted by this court stands vacated automatically.
yes, madam.
On 13/12/2021.
Madam, I discussed with my client. He has paid almost all.
No,
It is not about
Small
almost.
amount is.
Lordship, total comes your Lordship
The
85.
entire order sheet. It has
On
been reflected in the order sheet.
13/12/2021, this court has, an order was granted on the condition, granted
So next day
Directing
I will
the-
file it, the memo of calculation
the
and
arrears of
whatever
maintenance
the arrears of.
at the rate of rupees 7,500
500
per month
Yes.
from the date of filing of IA number 2 and criminal miscellaneous number 199 of 2018 till 13/12/2021 within a period of 8 weeks from.
No, not 21, Lordship. It has to be paid from the date of your Lordship, from the date of making the application in the criminal petition,
He said till today, that is on 13/12/2021.
deposited, yes, sir. Till today it has been deposited. Then rest of,
That is what is order.
Rest of that, your lordship, after that, she has not, they have not paid you.
Then now, that
So
will
I
be,
paid,
so,
my lord.
just wait, Mr. Counsel, till 13/12/2021 it is paid.
No, total amount was paid, your lordship, 2,000.
When you're saying total amount, how you're calculating? Till
It will,
today you're
till today, it
calculating
is becomes 8.
No, not till today. As per the interim order, it is from the date of IA till 13/12/2021.
Yes.
Whether it is paid or not,
Part of the amount has been paid, your lordship, 2,50,000 I have received.
Yes, my, that's what I submitted, my lord.
what you can do is, I will list this matter today. From the date of IA
Please.
till 13/12/2021, how much is the amount? You please tell the court whether it is paid or not, or what is left to be paid. That we will pass an order tomorrow.
Yes.
Is this matter tomorrow?
No, one 10 days maybe. I will get the copy and along with the arrears of maintenance, I will be with the, before your lordship.
Take your time tomorrow.
10 days maybe.
Tomorrow get that instruction.
Cell number
Yes.
2.
At the request of learned counsel, the respondent, list the matter tomorrow. Yes, two.
Cell number 2, Vijay Kumar TM.
Petition in this case, my lord, for a case. This case, father has filed a case against me under 125D in this case, my lord. Last occasion, there have been a proposal for 5,000 rupees. This has been discussed.
Huh?
My colleague has told me that last occasion has been the 5,000 has fixed the court and all. In this case.
So please use the mic, switch on the mic. I'm not able to hear you.
I think.
What is that?
Last occasion, previously the case was been listed.
Huh.
That today the matter was been 5,000 rupees has been discussed before this honorable court, my lord.
Subject to payment of 5,000, it was,
In this case,
Advised
my lord, even
during last occasion.
My lord.
there is an order of 10,000 per month. So more than 8 lakhs rupees still as and today there arrears is there, but you are not paid even after passing an order. You are not paid any 1 rupee.
My lord, kindly pursue the previously the same ex parte order has been passed and there afterwards I have been challenged in RPFC, page number 160 of page number, running page. In that it is observation, my lord. Even my father has they have been thrown out my mother also, my lord, and he has been out of the house and so many years, my lord, and he has beaten my mother, and he has domestic violence case has been filed against my father. It is was presently it was in running in is pending in before the Magadi court. My lord. In the same issue, he has my father has not even care about me and my sisters, even my mother also, my lord. And he is a retired HAL employee, my lord. My father was a retired HAL.
Is he getting pension?
Yes, my lord.
How
Some
much?
amount he is getting the pension and all.
How much he is getting?
And whatever the
He is
amount.
not getting any pension from HL. He is getting old age pension 1,200
No,
rupees.
when he is an retired employee of that company, why he will not get
HAL,
pension?
He is not getting pension. He only, there is no provision for getting pension from HL. He is
No.
getting old age pension. He retired during the year 2003. Kindly para 46, the honorable court correctly mentioned, material
What is his age now?
78 years, 79 years. He is residing in farmhouse. He is getting his income tax assessee and his annual income as per income tax assessment 8,40,000 during the year 2016. I produced before this honorable court, trial court. Taking into consideration of his income and also rental income and also his wife's income, the trial court has fixed a very nominal amount of 10,000 per month.
My lord, in this case, my lord.
Please come to the order of the trial court and tell the court what is wrong with this order.
My lord, my lord, I have been
Which
produced.
paragraph?
My lord, the paragraph number 35, my lord. Paragraph number 35.
Please read.
He voluntarily states that even though his wife has with the respondent from.
Paragraph 35 is not. You're reading
35 of the
from-
order, the
Yes.
judgment.
Which paragraph?
35.
It starts with further cross-examination of PW1.
Yes, my lord, for further cross exemption. Below then the para that maybe last that same para.
He voluntarily states.
He voluntarily states that even though his wife was with the respondent from 2013, he allowed his medical card and for the treatment of his wife. He does not know whether his wife was being treated at Nimas for psychological problem and Jaydev Hospital and Rangadore Hospital.
Yes.
My lord, even see that attitude and the second that he has admitted the suggestion that his wife was filed a criminal miscellaneous case against him for the maintenance. His wife had also filed a DV case against him at the civil judge JMFC Magdi. Of course, the petitioner has clearly admitted that he is not paying any maintenance to his wife.
Where is the mother
No,
staying now?
my lord, the income was there. The thing is
Where is
that he has been, all the.
Where is your mother staying now?
Presently with me, my lord.
Yes.
Most of my layout, he was staying in with me, with us, my lord. So my father also have the own house in the Bangalore city, and even agree he is all he's not allowed with to stay with us, my lord. And another one, the same para continuing, my lord. He's not paying any maintenance fees for. He is not having any money. Rest of the course of the cross examination and various bank accounts in different banks account details of the deposit. Of course, the petitioner is a owner of agriculture property measuring a 6 acres. He is also getting the income from the said property from the mango estate. He also own a small house at Jayanagra.
What is your salary?
My lord,
What is your salary?
presently he has a freelancer job he is doing, my lord. Once upon a time he was working in a biocon. Because of he was only the.
No, as per the lower court order, what was your?
What the lower court has been observed on the whatever the biocon, my salary was been at the time was 59,000 rupees was there. That salary has been considered, my lord. Not presently, the freelancer job has been not considered, my lord. So I have told the court that I have been working in a freelancer as a consultant or something. I getting the 20 to 25,000. So for that I can request to the court. But the court has observed that previously whatever I getting the salary, same thing was been continued, my lord. And in para 38 also the same is there, my lord, admitted by the PW1 was
Whatever
there.
are the reasons, and the father is not in a position to maintain himself, do you have the
My lord, I have no
responsibility or not?
The thing is, my lord, when I go to my village, I built a house in my own. That's a property was there. There also I built a one small house. From 1997, I am working, man. After the PUC, my father has been thrown out of the family, and I went to the Delhi and the SFL software. I worked. I sent the 4,000 rupees to my father account. There from that day and the IGNO University, Open University, I completed my BCA and MCA, my lord. Open University, I've read day and night in the Delhi only. I've sit in Delhi and working along with the correspondence course I completed. Thereafterwards, I joined the Biocon and I entirely taken the responsibility of my family. And thereafterwards, I've been married my sister and the elder sister also I had taken care, my lord. In 2003, my father has voluntarily retired and taken a amount of that amount also they has not paid a single rupee, my lord. And he is in the cross examination says that he is getting only the amount of 12 lakhs. He has received the amount of 8 lakhs rupees he is received from the HAL while he voluntarily taken, and he has distributed 5 lakhs rupees each all the persons. He has received the 8 lakhs rupees and distributed to all the persons 5 lakhs. How can it be possible? Whatever I have paid the amount because of my father. On that amount only, my father has purchased the BDA 2 sites of my lord in his name, my lord. My another one apartment was being purchased in the year of 2010, my lord. In that also, my mother was the second applicant and I was the first applicant. We both jointly we have purchased the apartment. So that also I have been because of it should not be. But because of all the issues, my lord, I have been from since, and he has the account more than 10 banks as well. 10 banks as he have the account in differently. That it was been admitted by the petitioner himself, the respondent himself, my lord.
Where is that?
That is also have been produced. The para number 14, my lord.
40.
Petitioner clearly admitted about his various accounts with various banks. He has admitted in that in the month of May 2015, the petition was being filed in the year of 2016, the month of 2015, while the cause of action date was being read. He had an account with the Canara Bank, an account with the SBI Bank, and he had an account with the Janata Cooperative Bank, Malleshwaram, Bangalore, Karur Vaishya Bank, Jayanagara branch, Sri Guru Raghavendra Cooperative Bank, Netkalapa Circle, TGMC Bank, Jayanagara National Cooperative Bank, Baswangudi. He voluntarily admits that all his accounts are now closed. So my lord, all these accounts are not has been closed, my lord. I have been produced that before this honorable court, that all three accounts in Magadi have the Canara Bank account and the account in Jayanagara and Nettalappa Circle, my lord. So more than the transaction has been taken place after the petition has been filed. After the petition has been filed, he is saying that I have the 3 lakhs rupees of loan has been taken by different persons, my friends and all things. His transaction after the 2016 more than a lakhs, my lord, per account. The person having a 3 accounts, I have been produced, my lord, before this honorable court, my lord. Even after the retirement in the voluntarily has been, my father has taken in the year of 2003 to up to 2008, my father has paid the income tax. He is earning more than the amount has been whatever the in 2000. After the 2003, he has taken a voluntary and he has paid the income tax 2008 till that date, madam. Whatever that amount is there, all those amounts has been paid by me only, my lord. Because I was earning, I was the family member, all the money has been given to my father only. So, my lord, even not only this, my lord, may kindly pursue the, again, admit it.
So what about his respondent has admitted the purchase of house site through BDA in the name of his mother?
Oh, yes, my lord.
You have purchased it in the name of your mother?
My mother, my lord. That has been sold. That has been sold by my father. He has promised to give to my daughter.
But registered in the joint name of respondent and the petitioner.
Another one apartment has been purchased, my lord.
What happened to that?
That is still, we are staying in that house. In that house, we are staying in the apartment. That is also my father has been, that is suggested that you should purchase this only apartment, and we went there, purchased it. But in that also litigation was been started. Then I filed a case
So
in
according to you, you have purchased it in the name of your father and mother?
Not no, my father and my mother, my name was been there in that.
So what is this petition and respondent? Come to paragraph number 44.
44.
About 8 lines from the top. Purchased 3 BHK flats for 70
Yes,
lakhs.
Dodkallu.
Registered in the joint name of respondent and the petitioner.
Yeah, that is Dodkallu near HL in the year of 90. Where
This.
Yes,
On whose name this for
so
property?
the BDS site was the plot was my name, ma'am. Both my mother and my name.
Then who is respondent and petitioner as per this?
No, petitioner has paid the amount. And he is telling that I have paid the amount, and the respondent admitted that purchaser house was signed through BDA in the name of his mother. The respondent also admitted that the petitioner purchased 3 BHK flat in 17 lakhs, but registered in the joint name of the respondent and the petitioner. No, my lord, it is not a respondent name. It was my mother name. That's the same 3 BHK house flat.
Here it is purchased.
In the year of, I think in the year of 2010, maybe 8 or 10, my lord. Before the 10th, my lord.
After retirement, my lord.
After the retirement,
Before you
I'm
purchase
telling
the
you,
property.
after the retirement only, you are paying the taxes and you are earning very good income and all things, sir. Even though you have been thrown out my mother and then after.
You can't answer to him, address the court.
The same issue, my lord. Why? The same observation has been made in RPFC previously.
You can't.
Para 45, my lord.
I am not denying any of this. My
lordship
father
kindly see
and all things.
45.
Even, my lord, even he have the post office account, my lord. Fixed deposits accounts is there, madam. Those, all these things as in assets and liabilities, he has not to say any words, my lord.
Para 45, my lord.
My lord, sir, ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ನಾನು ಒಂದು 2 ನಿಮಿಷ. So he has denied to give the accounts also in the that also, my lord, and continually he admits that in the same para, my lord, 40 para, page number 43. He admits that in the month of May 2000 his accounts were active. He was further admitted the Guru Raghavendra Cooperative Bank was closed due to the bankruptcy in year 2000. He received the 2,99,414 rupees from the said bank, and 26/6/2000. Some of the bank accounts were summoned by the court, and on the basis of request of the respondent, they are pertaining to petitioner. He has admitted that.
What was his salary while he was working?
He's not, he's in the farmhouse.
While he was working, what was the salary?
Retirement stage, he was getting 20,000.
He was, at the time of retirement, he was getting 20,000. Now he wants 25,000 maintenance from the son.
My lordship kindly see, He is totally, at the time of appointment, he was only small amount. When he had service ended, he was taken a salary of 20,000 and maximum
And from how long he's staying, he's separated from the family?
from 2012.
2000?
Tolu is separated and residing in farmhouse. Farmhouse and also parent address.
From when
No,
he's
no, no,
residing
my
separately?
lord. 2014, he has been separated from me, and he has residing in the Jainagra, before the filing of this 1 year before that, my lord. Before filing of this case, 1 year he has been separated from us only, my lord. He has been, my mother was staying with us at the time in the 3 BHK.
When, which year your mother has filed that domestic violence case?
2000, in the year of 2019, my lord. My mother has been.
You only defending that case on behalf of
No,
his
no,
wife.
no, 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 no. ಇಲ್ಲ, ನಾನ್ ಡಿಫೆಂಡ್ ಮಾಡ್ತಿದ್ದೀನಿ, ನಾನೇ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Yeah.
ಅದ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Then I'll not hear this case.
No, no, man. No, no, no.
Because this is not the way you argue.
There is no point.
Yes.
In that also, my lord, in various bank account, post office account also admitted by the respondent, he having the more than two, more than.
10 accounts he is having in the year 2004-5, they are all closed.
No,
How
no,
the court is
not
concerned with that?
2014, 2016 also it was been activated in the two bank, the post office.
So what is the amount lying in that? That is what is required to
My
know.
lord, presently, after the, when I called the summons to all the banks and all the, whatever I summoned to the, in the concerned banks, till that he was been, the amount was in the bank only, my lord. There afterwards, all the amount has been
From the
taken.
material on record, please tell the court, what was the amount that's there in, what is the amount in those accounts as on the date when those accounts were closed?
The amount was in more than 10 lakhs rupees.
Where do you get that? Please, please refer to that.
Please, my lord, my lord. That shares us, those documents was also not with me in the year of 2000, page number. My lord, page number 88, my lord, 88, 89. And that one first account, he was the Canara Bank, he was been having that account, my lord. In the year of 2000 January, the more than
2000?
January, my lord.
How are we concerned with 2000 January? The
2016.
petition is filed in 2016.
Yes, 2016 January only, my lord, I am asking.
Where is that?
March was been filed the case in the year of.
Now, what is the amount? Please tell the court.
That is one.
Refer to the particular page
Yes,
number.
ma'am. Particular page number, I will tell you exactly. The amount at the time the case was being filed. My lord, in the year of 2016, the page number March 103, my lord, he has the account of more than one bank account. He has the differently, he has been deposited 69,000 and thereafterwards it has been deposited from the different post office accounts. May kindly pursue from that 103 to, my lord, it will come to know that that is one bank account, my lord. Another bank account that is.
What is the balance that I want to see?
My lord, as on the date of statement I have taken from the call for the record 2022 January, his total amount was been transacted is 47 lakhs 52,000, my lord. That's the page number 115, my lord. Statement of summary. One bank account, my lord. In the year of 2022 January, my lord.
Where do you get that?
Statement of summary. Total debited and total credited amount was
47 lakhs 52,000.
Was the transaction in the year of totally.
Total credit amount
Yes,
47 lakhs.
debited and
Debit
credited
count
account.
248. Credit.
In the year, my lord, one account, that is one account. Another account, in another account. That is Magdi Road branch office statement, my lord, Canara Bank. Another Magdi Road bank statement, my
Yes,
lord.
what do you say on this?
My lordship, both are joint accounts, not individual account. We responded to his wife. And it is already elicited in the cross-examination. So that considering all these aspects, trial court has,
Joint account of yours and your father.
My lord,
all the three
kindly-
accounts are joint
no, no.
accounts,
It
not
is-
individual accounts.
Show it from the beginning, whose account it is.
It is
Page
Narsimaya,
number.
Narsimaya
Page
and
number.
Padmavati.
Padmavati is your mother.
Padmavati is his wife. His wife has been no income. He has filed a case against him to seeking that, my lord. He is no income. How can this amount has been debited, my lord?
On that time, there
That
was.
is the, if that is the, you have the income, why should you should have to produce the document, my lord? And another one account,
No, when you retired in the year 2009, 2003,
3 months.
Three.
how can you, if you, when you're saying that you don't have money to maintain yourself, what are this transaction of these 47 lakhs 62,000 in your account?
I have already answered in the cross-examination.
What is that you have answered?
Because it is a joint account. There is a daughter is a doctor, and another one doctor.
Let us see from the entries, where from those entries are. Look at the deposits.
There is a several, he has taken the loan from third parties and he cleared all those.
It is a joint account of you and your daughter. Why
A
are
joint
you
account means the daughter and mother.
not seeking maintenance from your daughter when both of you are
Accounts are
having this-
operated by both daughter and father and wife and all the three accounts
You
produced by
cannot
the,
say that your
all the
daughter-
accounts produced by the petitioner is in respect of joint accounts, not
No.
individual accounts.
When you have operated the account in the year 2021, question of your wife filing a case under Domestic Violence Act and 2019 will not arise. So you are operating along with your daughter this much of money, 47 lakhs 52,623. So what is the necessity for you for for maintenance? And when you are in good terms with the daughter, why don't you have maintenance from the daughter?
Daughter is already, he is also very difficult to make because he is only dental doctor. This is not
But
getting.
both of you are maintaining an account with the credits of 47,000 lakhs in 2021.
My lordship, already this aspect is covered by the cross-examination. Considering all those aspects, trial court has, the family
High
court has.
court might have, this court also has to consider and convinced with that.
And my lordship, it is,
Show what is the cross-examination. What did you say?
but today I am not prepared because anyhow, the para 45, my lordship, para 45.
It's in Kannada. Do it.
On perusal of entire material placed on record, this court is convinced by the petitioner that
I have seen it, because the court is convinced it has granted maintenance. Yes, I've seen the entire cross-examination. There is nothing as you are suggesting or you are submitting.
My lordship, I furnished the assets and liability wherein I have clearly mentioned the income, and he is also furnished the assets and income. So according to observation of trial code, is the bond and duty of the respondent to maintain his father. So at present, I am not getting any income except agricultural income. He is getting only old age pension. 10,000 is very reasonable, my lord.
What is he doing with the Jayanagar property? How many properties he require?
He is residing in three.
No, Jayanagar, he says, whenever I come to Bangalore, I reside in the small house in Jayanagar.
Small house. Whenever I come to Bangalore, I am residing. I am not getting any rental income. It is only 10 by.
Don't give it on rent, where will we get?
My lordship can see it is my house in Jayanagar. It is only 10 by 20. Whenever I coming to Bangalore from Paramos, I am going residing in that house. Not in. I am not entitled to for any income. So I absolutely I have no agree except
You have
agriculture.
6 acres of agriculture land. You
Yes.
have transactions of 47 lakhs in the joint account. You don't know how it is happening. You say that you have no connection with the wife.
It is giant.
Take care of the interest of the wife at all.
My lordship, it is a giant account. All the accounts.
In the cross-examination, you say it is not operated by my wife at all.
Look,
Yes, so-
that account itself shows that it is a giant account.
It shows, but that is your own admission in the cross-examination I'm referring to. That you said that your wife has never operated it.
I admit, my lord, but anyhow that I will convince.
Where from when you
I have already convinced in the cross-examination portion. That's why the trial court has taken into account and passed only 10,000 meager amount for climbing up 25,000. 10,000 is very reasonable.
Ask it to come. Let it be here. Take this one. Agreed with the order passed in.
Otherwise, my lordship can put final hearing. I will I will prepare and come and argue the matter. Any date may be fixed for
This
final.
is what we are doing, final hearing only.
Today,
Why was the court spending this much of time in the morning if it is not finally hearing the matter?
I am not prepared to final argument. I will let it post for final hearing and convince the matter regarding any merits application. Otherwise, there is some.
No, the other day, that's what was agreed.
I thought that it is only admission stage, so that's why my post.
2021, 2022 RPFC, now we will admit in 2025. No, unnecessarily, why was the court going through all this? If that request, you should have made it at the beginning.
My lordship, at least currently some extent of amount conditional order may be passed.
I'm not convinced with this case. This is matter on Monday. Finally, orders will be passed at the request of counsel, the respondent, and I'm going to dismiss it. I'm going to allow his writ petition. Yes.
Then number 3, Naveen Jain for petitioner. Ita Santosh.
The respondent.
In a case for a divorce, application was filed by the respondent wife, your lordship. Kindly see the application, page 31.
Oh.
Yesterday's matter.
Yes.
Page 31, your lordship.
Yes.
Application to strike out the pleadings, your lordship. Kindly see for a moment, page 31.
I think I heard it earlier at the time of admission. You argued it.
No, I have not argued. Yesterday, my lordship, there is some issue in the connectivity, so it was urgent.
So what's wrong with the order?
Lordship, kindly see page 31 for a moment. The relief is sought for to strike out the pleadings, your lordship. Strike out the pleading. Lordship, kindly see the.
MC is filed by her.
Pardon me.
MC
Filed with the
No,
petitioner,
filed by me.
husband.
Filed by me. Filed by me for the divorce, your lordship. The contention is, my lordship, to strike out the pleadings on the ground that earlier I filed a petition for restitution of conjugal rights. There was a maintenance of ₹5,000 to be paid to the respondent that have not complied. For that, my lordship, she has filed this application to strike out the pleadings, your lordship. Kindly see, my lordship, Article 16, Rule 60. What is the provision says, my lordship, to strike out the pleadings? For a moment, your lordship. 6 Rule 16, your lordship. CPC.
Yes, you can read.
CPC.
CPC.
You can read.
Striking out pleadings, the court
Yes.
may at any stage of the proceedings order to be struck out or amended any matter in any pleadings which may unnecessary, scandalous, frivolous or vexatious, which may be tend to prejudice, embarrass or delay the fair trial of the suit, or which is otherwise an abuse process of the court.
This is what is abuse of process of court.
Lordship, but the order is paused. Kindly see page 41, Your Lordship. The order is paused to stay the proceedings. The application was allowed in part. The proceedings were stayed till the payment of my Lordship, the maintenance of rupees 5,000.
Absolutely nothing wrong with the order.
So my contention is, my Lordship, insofar as that order is concerned, the MFA is pending consideration before this honorable court, Your Lordship. I have filed an MFA that is pending consideration. That has not been decided.
Why to be pending consideration? Was the order stayed?
Lordship, there is no stay order in the
Then,
MFA.
no, you can't, you file, you initiate the proceedings. There will be an order by the court. You say that let the proceedings go on. I will not comply with the orders of the court. Then where is the science?
My contention is that is not my contention that I will not comply the order.
You have to comply.
My contention is, my Lordship, the MFA is pending consideration, my Lordship. If there is a direction in the MFA, my Lordship, I will pay, my Lordship.
As long as the order is not stayed.
Please.
And it is staring at you, it's your duty to comply with the order. If you do not comply with the order, court has a inherent power to pass.
But my Lordship, my submission is only on technicalities, my Lordship. In an application to strike out the pleadings, whether the court can pass such orders, my Lordship, staying the proceedings. That is the technical issue, my Lordship.
Provision might not, it is not.
Provision itself
whatever is the
wrong.
provision, court can exercise its powers under 151.
Ultimately, my Lordship, the maintenance of rupees 1,32,000 I have
Has
to
to be
pay.
paid, has to be paid. If you want your matter to be heard,
Please,
you have to comply with the order. If
My
you are
lord,
ready to comply with the order, then the court,
So I will make concern. I will deposit 50% as of now, my Lordship.
My lord, approximately 2 lakhs it will come, my lord. It's the order in September 2024. Now it will come up to 2 lakhs.
are you okay with 50% of the deposit?
No, my lord. See, I will tell you, my lord. They have filed the petition for the section 9 application in 2021. That is dismissed, and this.
Remember the
Yes,
fact
yes, my lord.
yesterday you were telling
Yes,
that.
from that day itself, they are not paying the amount till now.
So 20,000.
And in the
Restitution is in the year 21.
yes, my lord.
Restitution is in the year 21.
Yes, my lord.
Second,
MC number 116 of
Having filed
2020.
having filed an MFA, questioning the order in the restitution, how can you file another petition for divorce on cruelty?
Lordship, because my Lord, she is not ready to join with me.
Then
my
you should
Lordship.
withdraw that MFA. How can the MFA be
So I'm ready to
decided?
take back, my Lordship. She is.
The whole intention is to stay the
Cannot
proceeding.
you
That's it.
have,
My divorce petition, my Lordship, because she is residing separately since from 5 years.
understand,
5 years. My Lord.
yes.
And there is a small child also.
1 second. When I filed in a petition for restitution, she is not ready to join with me, my Lordship. I have no other option, my Lordship.
You filed restitution.
Please.
She is not joining.
Yes, yes.
You filed MC for divorce on the ground of
But
cruelty.
in my Lordship, in the restitution, there was 2 orders. One is, my Lordship, the dismissal of the petition. Second is to pay the maintenance. But I have to challenge that also, my Lordship, before the
Then to that limited extent, you should have said, and court would have decided it. I'm confirming this order.
Lordship, I will ready to deposit you. Lordship.
And the order is confirmed with the judgment of this honorable court
I do
itself.
not want to dilute the order.
Lordship, because it is only stayed, my Lordship.
Once we start this, then there
It
is
is
no
only
end to
stay
that.
of the proceedings before the trial court, your Lordship. I am
You
ready
should
to
be- you
deposit,
should be-
with a condition that to deposit the amount. I am ready
To
to
deposit the
deposit.
entire amount. If you deposit, court will go ahead with the matter. Page number, order.
Lordship, order at page 41, your Lordship.
36, my lord. The order annexure E.
Agreed with the orders passed in I number 7 in MC number 13 of 2023 dated 25th September 2024. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience.
Lordship, may I request you, I will ready to deposit your Lordship.
Entire amount.
So 50% because there is a difficulty, my Lordship, that is the reason.
Or if you want time, I can grant, but not 50%. If you say that you will deposit in so and so time frame, then the court will proceed, provided you deposit it in that time.
I seek instructions from Lordship.
No instructions.
Then Lordship, grant me time, your
Now,
Lordship.
now itself you get
Or
instructions.
Lordship, grant me 8 weeks time, your Lordship, I will deposit.
1 month is enough, my lord. Already 21, they are
I am ready to deposit.
prolonging the
What-
matter.
What is,
How can you say something is
Oh, he's
sufficient?
an engineer,
You are not paying. Yes, he has to pay.
Yes, my
What
lord.
is not paid from 21 when you're
Till now, they are
getting,
not paid.
what you have not got from 21, when he's ready to pay in 8 weeks, why do you want to bargain on that? This will dispose of 8 weeks.
8 weeks. Worship, let the matter will be pending, your lordship. I will deposit.
No. No pending. Why should we pay, keep the matter pending? Yes. So and so. Initially, the husband had filed MC number. What is that MC number?
MC number.
Hello,
The section 9 application is 116 of 21, my lord.
116 of
21.
MC number 116 of 2021, seeking restitution of conjugal rights. That came to be dismissed or allowed?
Is dismissed.
Dismissed.
That came to be dismissed.
6/12/2022.
Dismissed, wherein the court has also directed the husband to pay the maintenance at rupees
5,000.
5,000.
at rupees 5,000 per month. The petitioner husband has preferred an appeal against the said order. Thereafter, the pending consideration of the said MFA, the present MC, that's MC number 13 of 2023 is filed, seeking.
Before that MC, my lord. Before that MFA only, they filed the.
Even before preferring the MFA, they have filed MC number 13 of 2023, seeking divorce on the ground of cruelty. It is the case of the wife that the husband has not paid the maintenance as per the order passed by the court. And he is again pursuing both MFA and the MC. And as such, an application is filed to strike off the pleadings. The court, relying on an order passed by this court in WP number 11721 of 2020, in case of HP Komala and Ravi Kumar, dated 29 July 2024, had stayed all the further proceedings. Then counsel appearing for the husband submits that when he has drawn the attention of the court to, what is that order?
Page 41.
He has drawn the attention of the court to the provisions of the CPC where it deals with the striking of the pleadings, and he submits that when an application is filed for striking of the pleadings, the court was not right in staying all the further proceedings, and the order that is passed is beyond the scope of the application, and the same needs to be interfered by this court. Then counsel appearing for the respondent wife submits that when they have when an order is passed by the court and the same is not complied with, and they come up before the court seeking a relief, but they do not want to comply with the order of the court. The court had rightly relied on the judgment of this court in Komala's case referred to Supra, and passed an order whereby the court had stayed all further proceedings till the arrears of maintenance are paid by the petitioner. It is submitted that there is no illegality with the order. Next, having heard the counsels on either side, for submit shall not record. The submission of the counsel that the application that is filed to strike off the pleadings is beyond the scope of the provision and the order of stay that is granted by the court is beyond the prayer that is sought in the IA, and as such the same needs to be set aside. This court do not find any force in the argument of the learned counsel for the petitioner. This court in Komala, HP Komala's case refers to Supra, had discussed the manner in which the orders of the court are violated and how the parties at one stretch are not complying with the orders of the court, and at one breath, and at the other, they're seeking the orders from the court and to grant the relief. They're seeking they want the court to pass an order which basing on the relief they sought. Extract paragraph. It is appropriate to extract paragraph number 10 of the said judgment. Take that 10 and 11. In this case, when the party has failed to adhere to the orders passed by the court, and immediately there is no stay granted by the division bench of this court in the MFA, when he is bound by the order and when he is not paying the maintenance, court exercising the inherent powers under 151 CPC for doing substantial justice to the parties had stayed the proceedings, and this court do not find any reasons to interfere. At this juncture, when counsel appearing for the petitioner submits that he is ready to pay an amount of ready to pay the entire arrears within a period of 8 weeks. In that view of the matter, this court is passing the following order. The writ petition, the order dated so and so is set aside on the condition that the petitioner shall deposit the amount within 8 weeks. If the amount is not deposited within 8 weeks, we'll ask the court to impose exemplary costs.
Sure, I will deposit you.
Within 8 weeks, the proceedings, further proceedings shall be stayed accordingly disposed of. Yes, next.
Cell number 4. Manohar and
I'll take steps in the course of the day.
A week's time.
Interim order may be continued.
A week's time for taking steps. Interim order, look at it as extended till the next date of hearing.
Match.
Kindly pass off.
Huh?
Kindly pass off. Senior ಬರ್ತಾರೆ.
Huh?
Kindly pass off, please. Response. Response.
Who appears for R2?
One.
And one again.
For R2, the notice has to go.
Yes.
Yes.
Cell number 5. Jagdish Sheji.
The petition, madam, I have filed
Takes
a
time.
rectification application, madam.
Huh?
I have filed a rectification application of a interim order, my lord. That interim order was like subject, it was stayed subject to the condition that the petitioner shall deposit 8,000 per month on litigation.
Where is the order dated?
It was dated 6/2/2025, my lord. Order
Six-
passed by this honorable court.
6/2.
Yes, my lord. There is a mistake in litigation cost of 8,000 per month, my lord.
No, in every case, that's what I'm saying. I cannot entertain these applications at all. 6/2/2025, coordinate bench of this court has passed an order. Now they're seeking the modification of the order. In several cases, this court is coming across these kind of applications. It is not appropriate for this court to modify the order. After obtaining the necessary instructions from the Honorable Acting Chief Justice, place this matter before the very same court. It has passed the order.
It's in
And,
Dharwad bench, my lord.
Huh?
It was passed by Justice Pradeep Singh Eru. It's in
That's what
Dharwad.
I'm saying. The steps, a week's time, default order.
Cell number 6.
Yes, my lord.
B. Ramesh for petitioner.
Completing the
Yeah,
first
many
this
yes.
matter. Lords, was listed the day before yesterday, my lords, where your lordships has directed me to verify as to what it would be the maintenance would be paying by the petitioner to the respondents, my lords. My lords, I have taken instructions. My lords, 20,000 would be paid till the disposal of the application which is pending consideration for interim maintenance, my lords. Lords, so the jurisdiction now it is being transferred to senior civil judge. As per the provisions of the Families Courts Act, my lords, it is for the civil judge, my lords, so it has to be dealt in. My lords, an impleading application has been filed by the High Court.
But what is happening? How can there be a transfer of this nature?
My lords, there was a
Unnecessarily
complaint
wasting
was made against the civil judge, my lords.
So if there is, no, let's see, where is the transfer order?
My lords, kindly refer to that order. Lords, at page 40.
Page 40.
In which year it is done?
My lords, it is on 2023, 23/9/2023.
23/9.
9/2023.
That is Principal Judge
Family Court.
Kolar has
Yes,
done
my
this.
lords. Who had the jurisdiction, my lords.
She has transferred it to?
My lords, she has transferred it to my lords, principal senior judge and CJM. My lords.
No, earlier where it is pending.
My lords, it was before the principal civil judge.
A family code.
Family court.
Put it
Yes,
right.
my lords.
Take this, 23/9, 2023, 23/9, 2023, as on the date. Who is this Principal Judge, Family Court, Kolar? Find out from Registrar R&S.
Lords, registrar has filed an affidavit before this honorable court for impleading, my lords.
No, where is that application?
Lords, I think.
It's not been served. One copy of the code.
Or that I am filing the memo along with documents, my lord. In that impleading application, there were two applications for marked, my lord. The same was not produced at the time of filing, my lord. The same has been.
One copy.
Lords, it's filed on 5/6/2025.
ಒಂದೇ ಕಾಪಿ ಇರೋದು ಕೊಡ್ತೀನಿ 2 ನಿಮಿಷ. ಅದು ರಿಪಿಟಿಷನ್ ಹಾಕಿರೋ ಕಾಪೀಸ್ ಬೇರೆ ಆಯ್ತು ಇಲ್ಲ. ಆರ್ಡರ್ಸ್ ಹಾಕಿದ್ದೀನಿ ಸರ್ ಅಷ್ಟೇ ಬೇರೆ.
Impleading application ಇಲ್ಲ. This order, my lords, is what your lordships are looking at 40. There was a transfer, my lords, which was ordered orally, my lords, in this form by the family judge, directing, my lords, this 125 applications which are there on the file of the family judge be placed on the court of the CJ. Maintenance applications, 125 CRPC applications then.
No, this has to be transferred to the Principal Family Court again.
Yes, ma'am.
Yes, but it has to go to the.
And what we do is, we'll do that. We'll set aside this order. We'll ask him to pay 20,000.
20, I'll just
till,
point out why not. I'll just 20 minutes. He is getting a salary of more than 4 lakh rupees. Minutes, the son Minutes is currently in his +1. Minutes, the situation was so bad that he was in a boarding school. Minutes, the mother had to withdraw him out of the boarding school because minutes, the expenses were not met.
What is his salary now?
His
Minutes.
salary is more than 3.5
No, my
lakhs.
lords, no, my lords. Now, next month he
At
is
least
retiring, my lords.
50,000 plus is
My lords,
what?
Excess here.
Yes, let him.
my lords, next month he is retiring. My lords, his salary is 1,25,000, my lords. As per his instructions, my lords.
I'll
I'm not
record it.
secure. I'm not secure.
One thing, I'll record it that it is salary is 1,25,000. If anything comes out of it, I'll also give a direction to the court to initiate perjury proceedings against you if it comes.
He has stated 1,61,000 knots, 1,25,000.
Let us, when the advocate is saying that on instructions is made to.
Very well, let him see.
I'll record that.
My lords, he has stated 1,61,000 in his affidavit, my lords. in
Then
his
why is he
objections.
saying 1,25,000?
Now, my lords, yesterday, my lords, he informed me that, my lords, now I,
Shouldn't have informed you.
Yes.
That means he is trying to even, after all, whom he is paying, his
Yes,
son,
my lords.
won't he take responsibility
Yes, my
of the son?
1,61,000.
1 lakh?
61,000.
What was ordered Minutes has been 50,000 rupees a month. Educational expenses Minutes. He is in +1.
My lords, it
Tuitions.
is not, my lords, the order passed by the family court, my
Tuitions,
lords,
my
he is interim
Humanitarian
maintenance.
consideration should be there. There's a moral obligation.
So we'll
being
forget
imparted.
about, we'll say that everything what has been recorded by the court is wrong.
Yes, ma'am.
Anyhow, then that's an order passed by a court which has no jurisdiction. That we are going to set aside. What about your moral obligation towards the
My lords, I
child?
will pay 20,000, my lords.
You cannot pay more than that. There should be a reason for that.
My lords, I leave it to the court, my lords.
There's something because you're
First, I'll
not
leave it to the
doing-
court, ma'am.
We'll say 40,000. The father is agreed by the,
There's a Minutes, one more. There's
Lords,
a civil-
40,000
1 minute, 1
for
minute.
both the petitioners, my lords.
For both.
What the application
May I
is sought,
request- Minutes, may I
something other.
request this, Minutes, may I request this? Minutes, only one problem is Minutes. There is a wife, that is one part, Minutes. But the child's Minutes,
so please understand.
I understand.
Cannot now accept remanding the matter, the court is not supposed to do
Absolutely,
anything.
absolutely. This is something which is human.
That's why no more
There's
submissions.
one more issue. There
Where is
civil
the
petition-
impugned order page number?
My lords, impugned order is page
No, before that,
40,
there are three.
47
petitions. 1 minute, sir, 1 minute.
40
There are three petitions which are on.
45.
1 minute. Three petitions are in your lordship's file. One minute has been filed by the wife seeking enhancement of the maintenance. Then there is a civil petition which is filed on your lordship.
Everything will go to the principal
Yes,
court.
because-
It will decide.
Yes.
It will decide. Now, for both the petitioners, for both of them,
Yes, ma'am.
40,000 he'll pay now.
Let's, one moment, CP is there for a moment.
Huh?
CP is there. There is a restitution application which has been filed in Bangalore. The wife not resides in Kolar, which is approximately around 100 kilometers away from Bangalore. Wife and son reside there. So this restitution application may very well be transferred to Kolar. That is
Everything will be done in this.
very good. I think that should be all.
That needs to be an application for that.
That is that.
My lords, that has not
Where
been
is the
served.
application?
Civil petition has been there.
Huh?
That has not been served on me, my
Where
lords.
is CP?
It is
First
listed.
matter, my lords.
Oh, it
6.
is here.
It's listed.
Where is that? First, give that CP also.
CP 440.
Who you filed the CP?
Yes, but the wife has filed.
Seeking transfer from where to where?
Bangalore to Kolar.
Oh.
Bangalore to Kolar.
You have any objection?
Lords, I have not received the copies, my lords, till today, my lords.
You can
No,
have-
anyhow, I'll record that you're
Yes,
taking
madam.
notice to the
Yes, my lords.
CP number, both the petition, WP 5939 of 2024 and CP 447 of 2023. What is the other WP?
For enhancement of this order, my
Ah.
lords.
Then WP number 14118 of 2024.
Both the contention and the writ petition be kept open, not so that the competent
Yes,
court
yes.
can decide on
Yes,
it in a
yes,
month.
yes,
in a
yes.
month.
You said page number 47.
Yes, my lords. My lords, commences from page number 45. Operative portion, my lords, is at page 48.
Starts at 45, yes.
Now, this particular application is only to the.
My lords, the application was filed. My lords, 1 minute, my lords.
Let him say that's his petition.
Ready?
Yes.
My lords, 125 proceeding, my lords, my lords, before the principal civil judge, an application for interim maintenance was filed.
No. What I want to know is,
Yes, my lords.
this order is arising out of an application for the
For in-
maintenance of the child or for the dog?
My lords, order is not at all passed on application. It's a oral order till the consideration
That is still to be considered.
considered.
Application is for both.
My lords, for both. My lords, that application is at page 19, my lords, annexure B,
19.
19.
It's a conjoint application made by the petitioner. Not stricto sensu speaking, not this application is maintainable on the very same code. 125 CRPC minutes is maintainable on the file of the judicial magistrate. And minutes it is on the file of the.
But all the, wherever the family courts
I
are
am saying
there.
where it can be held conjointly anywhere.
Yes.
Because they raise the plea minutes of lack of jurisdiction. It is not so. It is not a lack of jurisdiction.
No. Wherever there are family courts, these matters are heard by the family courts.
Even
125 also.
applications can also be heard by the magistrate. There is no.
It's
bar.
true, but anyhow, let it be.
I am
when
saying it is all right to go in one place. The
Yes.
plea of inherent lack minutes is something. What?
The wife had filed the IA seeking maintenance for herself and for the daughter or son? Son seeking maintenance of an amount of rupees
2 lakhs.
2 lakhs for both of them.
My lords,
1,000 per month.
my lords, for interim maintenance is 50,000 per each
Seeking
of the
interim
petitioners.
maintenance of 50,000 each to the wife and to the so-and-so. The court, before considering the application for maintenance, had granted had directed the husband to pay an amount of rupees 50,000 per month from the date of the order as maintenance towards temporary measure. Agreed thereby, the husband is before this court by filing WP number 5939 of 2024. On the ground that the principal, when the matter is filed before the family court, and the principal family court, the principal judge family court has transferred it to the senior civil judge, and the senior civil judge has no jurisdiction to decide this issue. And the other submission is when the IA, without even hearing the IA and without giving an opportunity to the husband and without there being any material on record, court cannot pass an order granting 50,000 as interim maintenance. In this case, complete petition is filed by on behalf of the Registrar General, wherein that this matter was already examined on the administrative side and the administrative side by the administrative judge as well as the Honorable Chief Justice. And by order dated 21/12/2024, a direction was issued to file a petition under section 482 CRPC. And even before it is stated that even before they take before they take further steps, the present writ petition is filed, and all further proceedings in miscellaneous number 68 of 2023, passed by the senior civil judge and JMFC Kolar, are stayed by the court. Hence, present complete petition is filed. Land counsel appearing for the respondent mother submits that when the husband is earning, according to you, 4 lakhs.
Yes, 6 lakh.
When the husband is earning 6 lakhs, 6 lakhs, it's his moral obligation to take care of the interest of the child and the mother, which he has failed to do. Further, he submits that as far as the criminal proceedings under 125 CRPC is concerned, the proceedings are maintainable before the are also maintainable before the senior civil judge,
Being a magistrate of
first class and JF first class magistrate. It is submitted that the court had rightly considered the plight of the wife and the child and granted maintenance of 50,000, which is a meager amount when it is compared to the financial status of the husband, and no interference is called for. He submits that the wife is residing in Kolar and the husband has filed the MC seeking restitution of conjugal rights at Bangalore. And they have come up with this petition as it is difficult for her to travel all the way from Kolar to Bangalore, which is at a distance of
70 kilometers, my lord. It is 70.
70 kilometers. Land counsel, Mr. B. Ramesh, appearing for the husband, submits that he has instructions to file wakalat and he'll file wakalat on behalf of the husband. The land counsel submits that the wife has also filed WP number 14118 of 2024 seeking enhancement of the maintenance as when the material on record discloses that the husband is having sufficient income, court ought to have granted the 1 lakh rupees as sought for as interim maintenance. And in the facts and circumstances, the same needs to be enhanced to 1 lakh. Next part. Having heard the counsels on either side, where is the material on record? So it's coming to the transfer petition, considering the fact that the wife is a resident of Kolar and she has already initiated the proceedings for the maintenance at the courts at Kolar. This court deems it appropriate to transfer the petition from so-and-so to so-and-so. Next, coming to WP number 5939 of 2024, which is filed by the husband, questioning the maintenance, and WP number 14118 of 2024, which is filed seeking enhancement of the maintenance. In the considered opinion of this court, when generally as a matter of procedure, in all when there is a family court situated in a particular place, all the matters pertaining to the maintenance are also dealt with by the by the family court, the principal judge ought not to have transferred it to a senior civil judge in the interest of justice. It is, this court deems it appropriate to withdraw the case from so and so and transfer the same to the principal family court, Kolar. Next, coming to the aspect of maintenance. When an application is filed seeking interim maintenance, there is a procedure contemplated as per the judgment of the Honorable Apex Court, either to decide an interim application or a final application. The court ought to have given a reasonable opportunity to both the parties and then could have decided the application. And still, now there is an order passed by the court which is not having jurisdiction. Even on that count also, this order needs to be set aside. However, looking at the financial capacity, according to the father, according to the husband, his income is 1,60,000, and according to the counsel appearing for the mother, his income is 6 lakhs. Even considering the income of 1,60,000, 61,000 as stated, as submitted by the counsel for the petitioner husband, and considering the plight of the wife and the child and his moral obligation towards both of them, this court deems it appropriate to direct the husband to pay an amount of rupees 40,000 per month as interim maintenance pending disposal of the IA that is filed seeking interim maintenance at 50,000 each. The pending application shall be decided by the court within 2 weeks. Within 1 week from the date of receipt of the copy of the order, both the parties shall file their respective statement of assets and liabilities, accordingly disposed of. Now, in the order, for every writ petition, operative portion should be there. Yes, sir.
Only one. That maintenance will have to be paid from the date of the application. That is the law of the Apex Court.
The order that 40,000 shall be from the date of the application.
The implementing application is coming. Implementing application.
Implementing application is allowed. What the order says? What this order is saying? Generally, when a maintenance is granted,
it's from the date of the
application.
That has to be considered, my lords.
That will be
The
considered.
merits order has to be considered.
Correct, it will be.
I will pay from this.
No,
Lords,
no.
if the
No,
he succeeds.
Please, no. At least you should pay. Where is that order? Date of order?
45.
My lords, 23 to 24.
Right from 23 to 24.
Sorry, my lord. It is 21/1/24.
21/1/24.
What happens, my application, from the date of the application is the law of the Apex Court.
Then I'll say, let the court decide it.
Yes, ma'am.
Court cannot pass such an order and let the court decide it.
Kindly see, I have been without
Understand.
maintenance for 3 years.
No.
3 years,
Then
sans maintenance.
what to do? Court shouldn't have, when there is a procedure to grant interim
Kindly
maintenance.
see, this order is not without jurisdiction. Only the transfer order was. This order is not without jurisdiction. That I can.
No, that I will record saying that without giving an opportunity to the
And
other
your
side.
lordship may kindly see, he has not read the entire order. I should not have,
Yes.
because it was being.
Yes.
But what the learned trial judge said was, she was given an opportunity. Give your statement of maintenance what you could do, because from 1 year before the family judge, the matter was being tossed on, saying that we will settle.
From the date of, in the facts and circumstances, from the date of the order passed by the court, you shall continue till today and shall continue to pay till the application is decided by the court.
That is
And
2 weeks, your lordship.
outer limit of 2 months. Yes,
Much of
sir.
that.
One more minute, sir. Let
What
us
to
be
do?
given a date so that we
What to
can
do?
appear.
Huh?
Let us be given a common date, because there will be a
Yes,
transfer.
without further notice, parties
On
shall
a
appear
particular
before the court by 8th of July, on 8th of July.
Yes,
Very well.
Yes.
My implementing application is
If your lordships could only come to the rescue of the wife and child by saying, from the date of application, 22, my lords, 24, I'll be losing.
No, that application court, once the court decides whatever is the amount, he would be paying.
So, I'll
That
be
may be
paying that
observed.
from
That may be observed. So he will not take up
once-
that plea again before the
once-
court there. That's right.
Once the
Correct,
court,
correct.
the law, my lords.
No,
I
let
cannot
it
stop
observed. They are all cantankerous pleas have been taken before the court.
Of course, this should not make such a submission, my lord, before this court.
My apologies if I have crossed the
But he
limits.
cannot go beyond his scope, my lord.
Wife and kid, they are without maintenance. A kid had to be withdrawn from a boarding school. Let's kindly see the plight.
But please understand, there is a way for, making submissions before the court. Court is considering beyond the scope of the
I know.
repetition.
I'm very-
Still, you are not
deeply-
satisfied. That's the whole problem.
We are deeply
When deciding the final application for interim maintenance,
Please.
the court, as it is considered, the maintenance from the date of petition has to be calculated from the date of petition for maintenance.
Great.
Yes, ma'am.
Great.
My lord, my implementing application is allowed.
As ordered.
Please.
Yes. What is this order? This on an application is filed to recall the order dated 17 February 2025, whereby this court had dismissed the petition for non-prosecution. Considering the reasons stated and in the interest of the parties, the order dated so and so is recalled.
In CP, ma'am.
Delay is also in CP.
Yes.
Delay is also so and so is also condoned.
Much
Yes,
of-
next.
Cell number 5, 7. Cell number 7.
A week's time. Default order.
Cell number 8.
And for the petitioner in this case.
What is this recalling of the order dated 28/10/2021?
That is, this court has, there was an office objection saying that interlocutory order is not revisable. He has to file a 482. Now, a warrant, attachment of salary
No.
order passed.
What is RPSC is filed against which order?
Interlocutory order. Attaching salary for.
It's an order finally determining criminal miscellaneous petition which he filed.
Let's see, where is that order which is impugned before this court?
In page 20, my lord, your lordships will find the typed copy of the order. My lord.
How can you call it a final order?
My lord, the honorable family judge determines that the arrears what has been sought for has to be recovered by issuing attachment warrant. That is the order that can be passed.
How can a RPFC is maintainable against this?
My lord, it is the family court that has passed the order, my lord,
Correct.
and
Then
not the
Then a
magistrate.
writ petition will, you can file a
No,
writ petition.
revision
against
petition
the
is maintainable. In fact, a division bench decision of
order.
this
Let's see the
honorable court.
order. Let's see that order of the division bench.
Yes. In fact, I persuaded this honorable court when it came up against office objections regarding maintainability.
Let's see
my lord.
that, let's see.
After seeing that order, the office objection was overruled.
It is already overruled.
Yes, madam.
Where is that?
28 and.
Lordships, Justice Rangswamy Nataraj has passed the order.
Let's see that. 28. Now, this order can only be filed under 227.
My lord, RPFC is maintainable. I'll
Please.
pass on the judgment.
Yes, sir. No, wait, I just want to look at how the office objections are overruled. Which date it is?
28/10/2021.
28/10/2021. Office objections raised regarding maintainability is overruled. Let's see, please show the judgment.
Lord, can I pass on? In fact, it's a jurisdiction exercised by family court under section 7 clause 2 of the Family Court Act.
Yes.
And that was interpreted, my lord, by the division bench of this honorable court. And it came to a conclusion that neither it is a civil revision nor a criminal revision it's a revision simpliciter called as revision petition family court, RPFC, against any orders passed by the family court.
Then what is WP?
My lord?
What is WP? Writ petition.
My lord, when there are no other avenues available under the enactment for assailing the orders.
No, WP, you're filing the WPs under 227, under the supervisory jurisdiction.
True, my lord.
Not that no other remedy.
No, but
That is not
19.4.
226, that when there
But
is no
90 section 19.4 grants remedy, my lord, to assail these kind of orders, my lord. This is an I have filed my objections stating as to
Oh,
how.
generally, what I have seen is what the pattern that is observing here with the procedure or what I don't know. There in Hyderabad, what we do is against any order of the family court, even for maintenance also, we find CRP that is under 227. The same thing, that revision you are naming it as WP under 227. The nomenclature is different.
But here, my
When
lord,
it comes to a revision RPFC, that is like against a final order.
true, my lord. This is indeed a final order, my lord.
How
I
can
can
it be?
justify with the
Final
submissions.
order is granting of the maintenance. That's a final
That
order.
I haven't assailed. That is,
That is a final order.
This has been filed under section 125, clause 3, seeking for arrears of maintenance for a period of 32 months.
Hmm.
And the Honorable Family Court has allowed that petition to recover arrears of entire 32 months. That is exceeding the period of 12 months as on the date of petition. So therefore, it's a final order. And he says it is pursuant to the admission made by the husband.
Let us see
But
which-
when there is no such admission, he filed a statement of objections to the petition.
Which paragraph? Let us read.
Paragraph of the decision, my lord. Yes.
Use the Family Courts Act also.
Yes.
From paragraph 10, we may read, my lord.
Paragraph 10.
From para 10 onwards.
Yes.
It is said that in chapter 4 of the act deals with the procedure the family court has to follow in the matter of the proceedings under section 7 subsection 1, and further the proceedings under chapter 9 of the code of criminal procedure under section 7 clause 2 of the act. Whereas section 10 of the act speaks about the application of the code of civil procedure and any other law for the time being in force in respect of the suits and proceedings, and further application of the code of criminal procedure 1973 or the rules made thereunder in the matter of proceedings under chapter 9 of the code before the family court. In this regard, mention has to be made that the family court had been given distinctly liberty to lay down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit or proceedings before it. Section 9 and 10 of the act in this regard reads as hereunder. In every suit or proceeding, my lord, the scope and conspectus of the powers of the family court has been described, my lord, and it
Come to
has been
paragraph
extricated.
11 about scope of 18.
Yes, my lord. It is further seen that from section 18 of the act.
Straight away come to paragraph number 13.
Yes, my lord.
Paragraph number 13 you can come to.
Yes. From the above provision in section 19(4), it is clear that an order passed under chapter 9 of the Code of Criminal Procedure 1973 is revisable order even suo moto by the High Court. Now to turn to the impugned order hereunder, challenge in the instant criminal revision petition, it is clear that it is the order one passed by the family court under section 7 clause 2 of the act. But the point is whether the same is a revisable order to be styled as criminal revision petition under the Code of Criminal Procedure or to be styled as civil revision petition under the Code of Civil Procedure. In our considered view, it is neither, for it is a revision, it is neither, for it is a revision simpliciter squarely falling under section 19 clause 4 of the act. No doubt the provision in section 19(4) of the act, as we see, is an analogous provision as the one we find under section 397 of Criminal Procedure Code. However, the provision of law in section 19(4) of the act reads that an order is revisable by the High Court either suo moto or otherwise. That being so, it appears to us that it is that is cannot that us that is cannot be said that the revisable powers under section 19(4) of the Act vested in the High Court is a revisional power either under the Code of Criminal Procedure or under the Code of Civil Procedure. In our considered view, the revisional powers of the High Court under section 19(4) of the Act is a revisional power simpliciter, totally devoid of the revisional powers of the High Court either under the Criminal Procedure Code or for that matter under the Civil Procedure Code. Therefore, in our further considered view, question of giving a nomenclature to such a petition under section 19(4) of the Act either as a criminal revision petition or as a civil revision petition does not arise at all, and as such a nomenclature is a misnomer. And further, my lord, in page 3080, my lord, 3080, there is a conclusion paragraph after reading a extracted clause, paragraph 6 of the full bench judgment of Kerala High Court, my lord. The conclusion para starts from the sentence, the above being the position. The above being the position, we find it difficult to be persuaded to follow the said order of the division bench to hold that as against the order under section 19(4) of the Act, it is the civil revision petition that is maintainable. Therefore, we are of the considered view that the revision petition maintainable under section 19(4) of the Act is neither a civil revision petition under the Civil Procedure Code nor a criminal revision petition under the Criminal Procedure Code. It is our further considered view in this regard that the revision petition under the said provision of law of the Act, that is section 19 clause 4 of the Act, is a revision petition simpliciter, and as such the same has to be nomenclatured as revision petition family court.
No, then if this judgment has to be
RPFC.
then why not all orders from the family court are revisable by the High Court? Then it should be all RPFC only.
Exactly, my lord. Exactly. All the final, which has attained finality, my lord, it needs to be filed under 19(4) as RPFCs, my lord.
And according to you, it's a final order?
Yes, my lord. Because the Honorable Family Judge has determined the petition by saying that the entire arrears is recoverable by issuing attachment warrant. That is the order he has made.
First of all, you are not appeared before the court.
We have appeared and we filed objections.
Absent.
We filed objections also, my lord.
Respondent absent.
That is on the date of the order, my lord. That is on the date of the order. Your lordship may kindly see the previous date order sheet, my lord. It bears that I have filed
Then
statement.
with regard to this 12 months and limitation, there is a judgment of the Supreme Court.
Yes, and this honorable court.
I have also passed several orders.
Dharwad bench has also followed that this is not a limitation, that it said.
I passed that order. There is a Supreme Court judgment. This 12 months, that whatever limitation is there,
yes,
that's not applicable for this.
My lord, that's not applicable in the petition that would be filed after the disposal of the petition under section 125, my lord.
No, that they know the such distinction
No,
is
that
made.
is the
What is that,
distinction
some
I have.
cartoon or something in the Supreme Court judgment?
Yes, that it is referred by the coordinate bench in Dharwad, saying that this 125(3) limitation which is.
I have also passed several orders in that.
My lord, this is a coordinate bench, my lord.
Where is that order?
Para 15 onwards, my lord, lordship.
Paragraph number?
15 onwards, my lord. 15 onwards, this is.
There is one more judgment of the Supreme Court.
In fact, I made a search also, my
This
lord,
is the,
to assist this honorable court. I made a search, but I couldn't get any judgment from apex court regarding
Is there-
this proposition.
para 19, my lord, thus the conclusion, my lord, in this case.
That, this Megha is Megha? Because several petitions are disposed of in execution proceedings with regard to recovery. I think if I remember that is some cartoon or something is the judgment basing on that. He said that limitation will not apply in recovery of maintenance. Look at it. There is a Supreme Court judgment. Basing on that, I passed order. So in that case,
My lord,
I think that's your only.
because whatever judgments I have gone
it
through,
is-
my lord.
That Supreme
Even
Court
in
judgment,
the-
my lord, it is referred in para 18.
Para?
Para 18 of this.
Take the judgment. Have you seen this judgment, Kuldeep Kaur versus Surinder Singh and another?
No, my lord.
1989 1 SCC.
No, no. My
Look
lord.
at this tomorrow,
My lord, Friday, my lord.
Friday.
My lord, one more thing is I had filed one more application for recovery of arrears, what outstanding. He has filed an objection stating that he will pay that amount, but check is not handed over to him.
What is that?
No, I filed the objections, tendering even the check when it came
No, the
before
check
his
was not given
lordship's.
to me.
One
He
nimsha.
has filed in the office. It
No,
is
no,
tendered
not
to
in the
house.
office, my lord. It came before Justice Narendra Prasad, my lord, and I offered the check and he refused to accept it. Then the lordship's
I did not.
hands were
refuse,
tied.
I am ready to
And
take it. He has not offered it to me. It is not recorded in the order sheet. Why he
He
is
is ready
saying?
to get the check next
Yes,
date
my
of
lord.
hearing.
I had promised him that I will get him today. I have brought this to.
But it is
When is the
refusing
date?
very.
When is the date?
My lord, I have not put the date. It's
Yes, not
open.
put
It comprehends a period of 12 months. According to me, my lord, as on the date of
Check
the
for how, what is the amount?
96,000.
He's for 1 year he is paying and he's contesting for
Then
the
counsel
other.
for the petitioner submits the check for an amount of rupees 96,000.
It's an open check. I haven't. He can put the date and.
96,000.
No, you can put the date, today's date.
Put the date with the you put today.
Today's
have
date
Today's
and-
date also.
Yes, and
For an amount of rupees 96,000.
yes, on the reverse, I have stated the period for which it covers.
That is between.
That is between 5/8/2019 to 5/8/2020, my lord.
2021 and 20 and the same is handed over
2020, not 20.
2020.
Yes, ma'am.
Please write it on a paper and give it to the court officer. And
From Monday.
the same is handed over to the land counsel appearing for the respondent wife. With regard to the legal position, the land counsel for the petitioner seeks time. List this matter on Friday. And by
Interim
the
order
time
may kindly-
the interim order earlier granted is extended and get the judgment, keep it in the file. Yes. Give him a copy of the judgment.
Please.
Yes, next.
Cell number 9. Home check area.
I'm appearing for petition, my lord. My lord, Annex D is, my lord. Trial court is withdrawn the applicant, my lord. Tejaswini withdraw this case, my lord. Deposit 50% of interim order prakara, my lord. 50,000 or 52,500 amount the withdraw the petition, my lord. Withdraw the memo application file, my lord.
There is a memo for withdrawal.
16/4/2025, my lord. Now for withdrawal.
Office is directed to return the original document on the basis of the memo and objection to the memo. The petition has withdrawn, keeping the contentions of both sides open. What is it? Withdrawn, keeping the contentions open. Who has withdrawn? Wife has withdrawn.
His husband is withdrawn, my lord. Applicant is a trial court withdrawn the case, my lord. 347/2021 case the withdrawn, my lord.
Who is the applicant?
Family got wife, my lord.
That's what I'm saying. Wife has withdrawn according to you.
Case withdrawn.
Where is the other side? We'll wait for the other side. No representation for the respondent. List this matter tomorrow.
Till number 10.
Petitioner in 5493.
Gita Mishra.
Your Ladyships, we are before you for compliance of your order dated 10/6. And I have to beseech your Ladyship under Article 141 on certain aspects. May we first comply with your orders, your Ladyship?
1 minute. Give the order sheet.
My lords, in the last date of hearing, this honorable court had asked us to submit documents and serve the same upon each other to prove the residence of the child with the mother, please, my lords. The documents are ready, my lords.
To file? To file?
My lords?
You have filed?
My lords, only after serving upon the advocate on the opposite side, I'll file it in the registry, please, my lords. The documents are here.
Have you served on him now?
No.
Yes, my lords. I will do
Your
it just now, my lords.
Ladyship, may I beseech a little intervention here, because we have done this argument even before the Honorable Supreme Court. This is 3 times. That is why it becomes very important. Now, as I complained last time, IA number 1 of 24 for recalling the order of your predecessor,
Sir, that cannot be pressed at all.
Justice Honorable Krishna Dikshit, was not passed with respect to a speaking order, or for that matter, a written order. When we applied for the certified copy, we have now come to know that that IA was filed by an advocate who is not even on record in this case. This is very serious. And that is why we are alleging forgery, as has been going on. Even in the Honorable Supreme Court, when we filed CRPC 340, the only reason why she was not punished, the mother, I'm representing the father, was because she's a woman and her petition was dismissed. Now, your Ladyship, this becomes very serious. I have obtained the certified copy. Please see the cause list thoroughly. Not served on us. This advocate is not on record. That is why we are filing fresh CRPC 340 application.
Appointed by the
We are
legal
talking of
services,
Asha
committee, please,
Mehta
plots.
and Asha Mehta,
That's not
and
me, my lords. I'm
they
Gita
are
Mishra.
claiming that they are from legal services and whatnot. We have filed RTIs, we have filed for wakalats. None of them have been directed to appear from legal services also. In fact, this is classic example of fomenting of litigation. Now that advocate Asha Mehta and the current advocate here were both fighting to represent the mother in the trial court. So this is gross criminal contempt of this honorable court. I am bringing this to your notice via separate application, and now I'll produce case laws of the Honorable Supreme Court as to what has to be done under Article 141. I beseech just a couple of minutes. This is very serious. Without serving us a copy, the allegations made are against the previous counsel who is also present in court. She gives NOC to the current counsel without obtaining NOC from that counsel who has filed IA number 124.
My lords, he's
And
complicating everything.
and
That
she
is
keeps
totally
on
unnecessary.
saying that I have been authorized from district legal services or high court legal services to appear in the matter. This is the seriousness, your Ladyship. That's why this is 3rd round where I'm fighting for CRPC 340. I'm profusely grateful for your order dated 10/6. May I highlight all these irregularities, especially what the Supreme Court says, taking adjournments. Now we are faced with another problem in the trial court. The mandamus is dated 23, your Ladyship. Till now, mandamus is not being implemented.
Why? Because this court is hearing the case, my lords.
This 23/3/2024 application, where is the wakalat?
Please check. We have all the.
That is in WP number?
Yes, WP number 5493.
54?
Yes, we have certified copies of the wakalats, 5493.
Take that.
This advocate is not on record.
IA number, sir.
My lords, I've
IA
just come
number
in
1 of
3
24.
months back. I've been appointed by the legal service committee for a simple reason, my lords. This advocate does not allow any advocate to represent the mother, my lords.
That is
More than
also
4
false. She
advocates.
is not
My
been
lords, even on the
directed.
4th, in this corridor, my lords, I've literally hit him, my lords. The kind of vulgar language he uses for the lady advocates. I've even filed a complaint against him, my lords. I'm forced to say this before this honorable court, which I didn't want to do it. It does not allow
We
any
have
advocate
already
to stand
taken
before
action
the,
against
for
her
any of the clients.
in the division.
Let me hear.
Yes.
This is the normal thing. My lords, he could have done the same thing on the last date of hearing also.
IA number
He doesn't-
1 of
he doesn't
24.
choose any of these things, my lords. Where he's cornered,
24.
he knows he doesn't have anything to say. My lords, after the court, this honorable court is seized of this case. My lords, is it proper for the trial court to have parallel proceedings, please, my lords? In spite of that, my lords, I've submitted the very first thing, my lords, where he has given a memo on 18/6/2025, asking the trial court to start the proceedings. He says you are violating the orders, the mandamus of the Honorable High Court. That trial judge, who is a new judge, literally panicked. Now she has again recalled everything, and she has posted it for the stage of respondent evidence. This is the kind of suppression of facts, misleading the court. My lord can just have a look at this. My lord, I've got the certified copies.
No.
My lord can just see
Before
this.
we go into that, we'll deal with everything.
Everything,
We'll
please.
deal with,
I will respond to
what
all
are-
this perjury.
My lords, we
Deal
will
with
give
what
the documents, please, my lords. Let the documents be
We'll
submitted.
deal with what the petition is doing and what the respondent is doing. Now, please tell the court, coming to the first thing, what about who filed this wakalat?
My lords, I have come in the month of April, please, my lords. Legal
There
Services
is a
Committee.
party. Where is a party?
My lords, she's in West Bengal, my lords. She's in Malda, West Bengal.
So she's happily staying there and
No, my lords.
she's asking somebody or the other to file the cases like this.
My lords, whenever necessary, she's here, my lords. The husband is
So
not
has
paying
she
for
given
any maintenance.
wakalat? Has
Yes,
she
my
given
lords.
wakalat?
Yes, my lords. My wakalat is there. It's in IA 1 of 20.
You're saying that you were not there. I'm referring to the review petition. I'm not referring to your wakalat now.
Yes,
Review, who filed the review?
Asha Mehta.
My lords, to revive the petition was filed by me, my lords, on 0104
Whatever is it is, what do you call this? That who filed it?
I don't even know that, my lords.
Give it to her.
I'm not aware of that, my lords. My lords, I've just come into this case only 2 months back, my lords.
That's
So
why I'm
one
not
thing-
asking you whether you have done it. Your client should know what has happened.
Information concern the dealing in the trade.
And you know, the manner in which these family matters are fought
Yes,
by
my
the
lords.
clients, by the advocates from both the sides,
Take
it's not
personal-
right.
It shouldn't be personal, my lords. End of the day,
That's
justice
the whole
must prevail.
problem. That's the
My
whole
lords,
problem.
This is about some other advocate, my lords. I'm not even aware of this.
That's why, because you know, what is this happening? How is this kind of applications are filed? Because she is like, when she is not able to engage an advocate, where from these advocates are coming? And she has taken the legal services.
My lords, she approached the Legal Services Committee, and I was called by the member secretary with a simple thing, my lords, because she had said that more than 4 advocates. My lords, if you just have a look at all the order sheets, my lords, everything has been got ex parte, my lords. There is no representation for the mother at all. Even WP 8683, where a false submission was made that there's only one divorce petition filed by the husband in 2021. He suppressed the fact that a divorce petition was already filed by the wife in Malda, the jurisdictional court, way back in 2017. He suppressed that fact, but there was no representation for the mother, for the wife, before the coordinate bench of this honorable court. He does that. That is why she approached the member secretary.
No, please understand. What the other advocate, the advocate appearing for the husband can stop the wife from having a representation on her side. What is that he's doing?
My lords, like the way I don't want to repeat again and again, lords, the only thing is what is ordered by the court at that date, that is not countered at the same point, my lords. Time is taken, lot of other manipulations happen, different memos are given at the trial courts. And again, when this honorable court has very clearly said, he could have raised this issue long back. Why now? On 10/6, my lords, when this honorable court has passed a very specific order recording that the interim custody order that was given by the coordinate bench of this honorable court for the month of May has been complied with. That was a false submission. This honorable court has recorded that. Now I'm giving documents which shows there's a lot of contempt that has been committed of all the orders of this court. Now to overcome all that, he is bringing up all this, my lords. He could have made this submission long back. What made him wait for 1 year, please, my lords? Why he didn't bring this up in 0104 before the coordinate bench of this honorable court, Lordships Justice Krishna Dikshit? He had 3 hearings, my lords, and last 2 orders were consent orders. It was in-camera proceedings. All of us were out. Only the child, husband and wife were there. If the orders dated 29/4/2025 is seen, please, my lords, it is very clearly recorded. It is an in-camera proceeding, and it was a consent order between the husband and wife. All the terms and conditions stand violated. Why wasn't this raised?
MC is filed by whom?
My lords?
MC is filed by whom?
By both of them.
My lords, MC was filed first by the wife. MC 508.
Both of them want
2017.
divorce.
Yes, my lords, they want. Let him give it now, my lords. Let them sit. That's the reason I put the IA 1 of 2025 in 8683.
So if he wants divorce and she also wants that, what is the difference?
Yes, let them sit and settle, please, my lords.
Now, Your Ladyship, when the mediation talks were taken up by the Honorable Supreme Court, there was a figure of 2.5 crores quoted there. Mediation failed. Then she has used legal terrorism over here. There are 18 matters pending. And
What I
she,
request both of you is,
Yes.
let us use the words which the court and everybody
respect the
understand,
court.
and it is
This
more,
is- this is
more
defined.
comfortable.
Respect the
to
temple of
this is
justice, please, my
defined-
lord.
Let maybe, let whatever your
Defined by
feelings
the
may
Honorable
be,
Supreme
let
Court.
us use the simple
Fine.
words, please.
the Honorable Supreme Court has defined this in Sushil Kumar Sharma.
Not
Nonetheless.
necessary. We all know
Nonetheless.
judgments, not
Nun-
required that we should use
Nonetheless.
everything here.
Yes.
Yes.
I bow down.
Yes.
Now, Your Ladyship, the final offer was made in the transfer petition filed by the wife, which came down to 20 lakhs. Then she went back on it and said 20 lakhs plus one flat, which was not agreeable because she herself has 3 houses. She's staying in Calcutta, she's staying in
Where's the
Malda, and she's staying in Gurgaon as well. So the mediations failed. That's why she withdrew the petition. 11 months she stagnated it, and she had used all the pressure tactics. That is where 8683 WP comes in. And I had to file petition, which is now before you in 34901. So he is absolutely amicable with respect to giving her 20 lakhs as long as she doesn't take custody of the child or agrees for shared parenting. But she is against it because in 8683, we have exposed the fact that she will go away to Canada with another man, and she does not want to give custody to the child. It is there in 8683. Everything is recorded.
Before both of you proceed,
Yes.
I am giving a patient hearing to both of you.
Please.
When the other advocate is arguing, I don't expect the another to interfere.
Now, Your Ladyship, subsequent to these two advocates coming in, fomenting of litigation is taking place. I have been in this case from 2018. I'm running it to the absolute.
Okay, you are taking care of your client's interest. Don't
Please,
say that what they are doing
please.
is right or wrong. It's for them to
14,
decide.
yeah,
Just
for
tell
Your Ladyship
case.
to decide.
Yes.
14 advocates, Your Ladyship. and the-
Maybe she has her own
Yes.
problem for
And-
your client has a capable advocate like you. That's why he's having you. Maybe that's why they are not capable and the client wants to change.
I bow down.
Not
Yes.
capable.
As per the records, they are not on wakalat. Most importantly, the advocate who filed this recall order makes the entire proceeding non-a ab initio because this order of disposal in 23 was not recalled. Even before his lordship, I complained. I don't have the copy. I don't know what has happened. He passed an order for the.
Before that, what I want to ask you is,
Yes.
why do you want to make all this so complicated?
Yes.
It is not about winning the case. It is the lives of people are involved.
Correct.
Don't make it too technical.
Please.
And try to understand that there should be a let out from this problem. How do you do it?
Yes.
Now, what is that your client wants?
My lords, a small submission, lords. When the mediation was happening in the supervision
I'm
of
not
Supreme Court-
interested to know what has happened.
Milords,
Please
1 minute.
understand.
Milords,
Let's
please.
not go into what has happened.
Milords,
Please tell
defamation
me.
cases for a tune of 15 lakhs was filed by them, Milords.
What is that?
Defamation case on the
Leave
wife.
away all
So,
that. Now,
this
for
is
the
very derailing, my lords.
once
Yes.
all these things are settled, everything will go.
Correct.
So what is the settlement your client is expecting?
My lords, any date, I will ask her to come down, please, my lords. Let her be present before this honorable court. Any short accommodation, please, my lords.
List on Monday. On the day, both the parties shall be present before the court in the chambers at 2 o'clock.
Grateful, my lords, grateful, my lords.
Court officer, a
Milords,
copy.
Do we have to submit the documents?
Yes, whatever
now,
it is,
Yes,
you
please,
give her and give him and file
Please.
what she wants. He gave some paper that he
Yeah,
wants, I
at
think.
ತಗೊಳ್ಳಿ. At file ನಲ್ಲಿ.
Court officer, ದಯವಿಟ್ಟು ಇದನ್ನು ತಗೊಳ್ಳಿ.
ಅದಲ್ಲ,
Milords,
ಇದು
ಅವಾಗ madam ಅವರೇ,
ಇದು ಫೈಲ್ ನಲ್ಲಿ.
Yes, my lords are serving a copy upon him.
Do it,
In the court,
do it and file it in the registry.
Yes, we are also doing it in court.
Yes.
File ನಲ್ಲಿ ಇರ್ಬೇಕು.
Before the registry. Yes. Court in chambers at 2 o'clock on Monday.
My lords, she may be directed to collect the copy, please, my lords. Because we send by post also, they say it's not. they don't-
What is this? Why you don't take the copy?
Yes, please, sign here. Grateful, my lords. Check all the papers.
Very unfortunate. Next.
Cell number 11.
Grateful, my lords.
So waiting for the petition
Nagaraja asked.
led by senior counsel, my lord. She's unable to come before today, my lord. I've already informed the other side last night itself. Not urgent.
What is this? Dispensation of the, it's coming up for dispensation.
They file-
IA is coming up. IA 1025.
Yes, my lord. My lord, I am led by senior counsel, my lord. She's unavailable today, so kindly have a short accommodation.
This is matter on Tuesday at the request of land counsel for the petitioner. Yes.
Much obliged. Much obliged.
Cell number 12. Cell number 12, Manjunath B.R. for petitioner.
Allowed for the petitioner.
Abdul Ansar.
What are these,
My lord,
IA 1025 for
had
translation
filed an
of English?
application, my lord, seeking dispensation of the translated copies. But nonetheless, my lord, subsequently I have furnished translated copies also. So that being the situation, my lord, I think IA 1 of 25.
Doesn't survive.
My lord, there is some urgency in
Please
this
argue.
case. My lord, I am the husband, my lord. And coming to the gist
IA
of the
number
case.
1 is filed for translation of English to Kannada and Exhibits so and so. Then council submits that as he has already filed the copies. There are no orders are required to be passed on IA number 1 of 25, accordingly closed. Yes.
My lord, I am the husband, my lord. The gist of the case is, my lord.
What is the impugned order first?
My lord, visitation rights in respect
Please
of.
come to the impugned order. Let me
Impugned
look at the
order, my lord,
order.
is at
Then
page
you can
number
make your submissions.
18 to 19, my lord, page number 18, 19. My lord, if your lordship sees.
Come to the operative portion.
Page number 19, para 5, my lord.
Police station, place of visitation is from women police station to?
For visitation rights in respect of 2 minor daughters, my lord, who are aged around 7.5 to 5.5 years, my lord. The venue for when.
What made the court to pass this order? Let us see what is the reason stated.
My lord, para number 5, my lord. In this memo, the respondent is only seeking for shifting of the place of visitation from the women's police station, Hassan.
What is this visitation in a police station?
Lord, the order is that, Lord, the visitation venue is fixed on.
Did you question that order?
Yes,
Where
my
is
lord.
that?
My lord, may I just state the antecedent facts as to why things have shifted to the police station?
This order is asking
Shifting
from one police station to the other police station. There must have been an order passed where one police station is fixed as visitation place. Have you questioned that order?
May I just, for this, I'll come to the point as to why police station to police station. First thing, my lord, the visitation rights was before the ADR, that is mediation center.
Where is that order?
My lord?
Where is that order?
My lord, if your lordship sees page number 94 to 98.
So this 94 order is dated.
Please, my lord.
17/1/25.
25, yes.
The place of visitation could be modified as Spandana Center in the office of the Superintendent of Police. If the parties do not agree with this place, the parties may file their respective memos mentioning the reasons and suggesting any convenient place within 1 week from today. So you have not filed any memo.
My lord, may I just?
From here you tell me.
Yes. From here.
Ah.
My lord, initially it was before the mediation. Subsequently, it was referred to the Spandana Center, my lord, which probably has a specific designated area so that people, as far as husband and wife and children, my lord, they are given a designated place to sort out whatever, my lord. That was before the Spandana Center. Subsequently, Spandana Center, my lord, it had to undergo some renovation before the in the SP's office, for which, my lord, an application was filed that let us shift this venue from Spandana police station to a women's police station, which, my lord, in the town of Hassan, they had a specific designated place for children as well as for people who have, for husband and wife who have their own differences. So this was by consent. This being the situation, my lord, they also agreed to that. I also agreed to that, taking into consideration that, yes, this is a conducive place. Subsequently, they file an application stating that from the women's police station, that is Hassan, my lord, it's a district headquarters. From the district headquarters, kindly transfer the venue of visitation from a district headquarters to a taluk headquarter police station, because we are residing close by and it is only 3 kilometers away from our place of residence. The children, my lord, they attend school which is around 15 kilometers away. Whereas
are you meeting the children in the school hours? No.
No, I'm not.
Meeting them on a Saturday.
Saturday and Sunday.
Then both the days, why do you want them to travel 15 kilometers?
No, it's only a matter of 15 kilometers where, my lord, it's a daily routine for them to go to school also.
What is that you're
my lord, meeting children, my lord, in a police station.
You want?
My lord, let it go back.
You are mixing two aspects.
Yes.
First, there is no difficulty for you to meet in the police station for the reason you say that in those police station, there is a earmarked place for the children.
Yes, in the previous police station.
So now when something is 3 kilometers away from their house and you say because every day they're traveling 15 kilometers to go to the school, let them come to that place.
My lord, may I make
You
myself
have to be,
clear?
being the
My lord,
father, you should be mindful of the, the
My lord,
difficulties of the daughters.
My lord, I think I've not made myself clear. Spandana police station, women's police station, my lord, it has a designated area where the place, my lord, is conducive.
15 kilometers
15
away from the
kilometers
house.
away.
Yes,
That is one thing.
yes.
Why I prefer that is because it's a conducive place.
Now what is the other place
Lord,
apart from police
One
station?
humble submission, lord. The place, the distance between the Arehalli, which is the venue of the visitation is fixed, and the Hasana, where he is residing, is having the 40 to 45 kilometers of distance. Traveling every week, twice, these hundreds of kilometers for a child is really adversely impacting on
So forget about that place. Now, which is near to your place? What are the places available other than the police station?
I'll seek instruction on that point. One humble submission in this. Why the police station were preferred is only the place on Sundays also, which is remain open, is police station.
What is the difficulty?
Difficulties
in the
is
police
that not
station?
in the ADR center or mediation center on Sundays, it is all remain closed. These petitioners.
Please tell the court why it can't be outside. What are the difficulties of the mother?
It can be blocked with the.
Listen, until there are circumstances where it has to be before something or under supervision. Otherwise, they're old enough. And are any incidents of any violence?
When it was there in the Hasana, his place of residence, there was the chaotic, dramatic situations arose a couple of times.
Then we'll do one thing. Now, this coming Saturday and Sunday, let it be in a public place. Where is the public place? Any mall or any park or what is it? There he will exercise. We will see how it goes on, and then we will modify this order thereafter.
Please.
Which place?
I can seek the instructions on that.
Tomorrow.
Please. Lord, may kindly have it on Monday, my lord. I'm just an arguing counsel on this.
Yes, Monday.
Serial number 13.
My lord, may kindly have it tomorrow, my lord. I'm told that the arguing counsel, he would be coming tomorrow. My apologies.
Please get instructions, Mr. Counsel, by tomorrow. What is a convenient place? And
Obliged.
tell her that we'll experiment it on Saturday and Sunday. Basing on how it works out, we'll modify the order.
Please.
13. Raja L for
This case
petitioner.
appear for the petition. I am challenging the order of Annexure E, my lord. The wife of filed the application for enhancement of the interim maintenance, my lord. The trial court, after hearing the application, rejected, my lord.
Notice.
Serial number 14. MC Roshan.
For the petitioner, your lordship, seeking direction from this honorable court for the speedy disposal of the
Which
trial.
court is this?
This is 4th additional Bangalore family court, my lords.
Which year is the MC?
MC is 2023.
No, there can't be.
I'll convince this lordship. That point is the matter was already posted for judgment. Then thereafter they come and file an application for recalling. In the sense, another petition has been filed in Kanakpura wherein the maintenance order has been passed. Every time the maintenance has been given and their presence is there in the Kanakpura court, but not in the Bangalore MC case. So that is why my grievance is that the matter was posted for judgment and thereafter they filed a recalling application, and now the matter is posted for cross-examination of the petitioner, that is the husband. They are not cross-examining the husband also, and they are filing a frivolous application for amendment, whatever the cause that has been done. Yes, my grievance is they are collecting the maintenance every month in the Kanakpura court, but they are not attending the.
For that you have a remedy. Go before the court, ask the court.
Yes, my lord,
the
that has
remedy
been
is
done.
not coming to this court and filing a petition.
No,
for
that has
disposal.
been done, your lordship.
Because 23, there are several matters pending in that court. Why should we give a direction?
I completely understand on that part, but my grievance was that
But that can't be addressed in this. Please understand. Please come. agreed with the.
Or else, my lords, it can be like this, my lords. Let the cross-examination be done in the time board. My humble request, only on that part. Cross-examination.
Yeah, I'll say in accordance with law. That's nothing else.
My lords, if that's the case, then again that my application will not survive.
We cannot pass an order because we are conscious of the pendency before the courts and
Yes, my
high
lord.
court
I-
can't be.
Even the tendency of the parties should be looked into that, my lords. That's the only request.
There is an order passed by me saying that if they are not cooperating in that, then you have
Has been-
either to strike off the pleadings or to stay the proceedings. You can make an application.
That has been
Because you
elaborated.
find the MC
Yes, my
and
lord.
ask for the striking of the pleadings if they are not cooperating.
Yes, my lords.
The writ petition is filed seeking the following prayer. This MC of the year 2023, considering the pendency in so and so, this court is not inclined to pass any orders by fixing a time-bound for time-bound disposal. However, considering the fact that the submission that the matter is already posted for the evidence of the cross-examination of the petitioner, the court shall consider the same in accordance with law.
Gratefully.
And without granting unnecessary adjournment. Same notice is not given to the respondent. Next.
Much
Number
obliged.
15, Fatima SK for petitioner.
Petitioner is the husband.
Yes.
Maintenance order that is passed. The court awards 25,000, saying that will help bear the educational expenses. The child is barely 2 years old and she's an MCOM graduate. He is ready to live with the Millards.
Come to the order. Where is that order?
Order, Millards at annexure. G is the order,
Page number.
75. Millards, it starts at 75. However, I'll come to the relevant 79, Millards.
Yes.
In the backdrop of these facts, at the end, Millards, I am of the opinion that if 25,000 is granted both to the mother and daughter, it would meet.
So, what is the income of the petitioner?
Millards, it's 1,02,000.
So 1,02,000.
1,02,000.
Yes.
She's an
is unemployed. Maybe she
unemployed. She's an MCOM graduate. Yes, but Millards, the fact is, without any basis, she's refused to live with the husband and is living with her parents. He is ready to live with her. The child is barely 2 years old and she has threatened to commit suicide. In fact, she had taken the child to a hill and even committed.
All of that will be decided in the.
Correct. I understand. Let there be a conditional order. He is ready to take her back. Always he has said that.
We will generally grant a conditional order basing on what is available. When your salary is 1 lakh, court gives 25,000.
Because he has his parents living with him. That is the problem with her.
He is having 75,000. Two people said 25,000.
Plus his parents are living with him,
That's what I'm
age-old
saying.
parents.
He has 75,000 with him. Even if we calculate them as 3 people and this as 1,
correct.
Still 1/4 is a reasonable amount.
Millards, unreasonably, without any basis, she can't be living and staying in her mother's house and start claiming maintenance for herself and the child.
No. Every spouse has their own reasons. We cannot say desertion until and unless there is a decree of by the court after a full-fledged evidence.
Plus, her demand is that
we cannot consider at this stage, and there is no difficulty for the husband to pay. We can only order.
That's exactly what I'm saying.
This is the respondent.
Plus, let there be a conditional order. Even 10,000 is, I think, would be fair enough, Millards. Whatever it is, let it be decided after the court hears, Millards.
If at all you want only order, I can give it. We will grant it on 20,000, not 10,000.
Plus 25 to 25. I'm not.
That's why I'm not passing any
let
order.
there be, I think, a 12,000 also, because there is no educational expenses.
Notice to the respondent. The petition is permitted to take out hand summons on the counsel
I'll do
appointed
that.
for the respondent. Once the memo is filed, list the matter. Yes, next.
Plus, let there be a conditional 12,000 till then, till it is listed at least, Millards.
No, there should be a reason. Just like that, because the writ petition is filed, we can't reduce the amount.
No, this thing is, the court says educational expenses and the child is barely 2 years
Not
old.
education. They have to live. 2 people have to live, and she's not having any maintenance.
And she's living with her parents in her own house and does not want to earn.
We'll see
income,
once the
graduate.
husband comes, we can decide the matter itself. Yes.
Number 16.
Plus, I'll also take off notice on the council also.
Council only, I said, hand summons on the council.
Great.
Notice to the respondents also in the edition. Yes.
Appearing for the petition in this matter. Petitioner is the husband, my lords. There is a GNWC petition pending before the family court. Husband has sought for the custody of the girl child. The main contention and the dispute between the parties is that, my lords, the respondent wife, who has
To the
got,
impugned order first.
kindly come to my lord, page number 61, annexure E, my lords. No doubt IA 5 is filed before the family court in GNWC for the interim maintenance.
Please come to that.
Yes, my lord.
61.
Page number 61.
Mm.
Any of the petitioner and his counsel is continuously absent, it is necessary to pass the order for interim maintenance. Hence, the petitioner is hereby directed to pay
This
monthly
is a
maintenance.
MC of which year?
It is not MC, my lord. GNWC.
GNWC of which year?
2018.
When is IA filed for maintenance?
IA is filed in the year 2019, 27/11/2019.
So from 2019 till 2023, no order on the interim maintenance.
No, my lords, there was no order. Subsequent, my lords, the main contention here in petition is taken that, my lords, petitioner is working in Andhra, my lords, in a bank, in a scheduled bank in Andhra Pradesh. And though he was kept on requesting his advocate, he was not intimated on it.
Before that, you are assailing which order?
I'm challenging the order at annexure E only, my lords, GNWC.
26/2023.
Yes, my lords.
You are assigning it in 2025.
Yes, my lords. It in order itself is not at all
Notice to
intimated, my
respondent.
lords. The trouble is that, my lords, now the GNW execution is been initiated by the wife, my lords.
Let them execute.
Lords, if petition, lords, if directed,
What is the good reason that you have not come before the court for 2 years?
lords, the first of all, advocate has not at all informed the petitioner. Both the counsel and also petitioner is absent, my lords. No doubt that it is also recorded in the order sheet of the
Are you not,
GNWC.
when the case is instituted, won't you find that what is happening before the court?
My lords, first of all, though he was asked to the advocate, my lords, he was not at all intimated. That is the request he has
Petition is
put out.
permitted to take out notice on the hand summons on the counsel.
My lords,
Preparing for the, no.
one more contention may kindly be taken. After the filing of the application, my lords, the trial family court has directed to file assets and liability from respondent side also. It is not even filed before the trial court. Without having considering that fact, my lords, the interim order of maintenance is
First of
filed.
all, coming to the court after 2 years, all these counts this court cannot consider. That delay you are saying that counsel has not informed cannot be considered. An application that is filed in the year 2019, 2023, and that means till from 2023 till now you are not paid anything. Then who will take care of the child?
Lords,
What is your responsibility?
as far as the child is concerned, my lords, I am not denying it. So even
So
we filed the
maintenance
GNWC.
is for the child, not to the mother.
Both they ordered, my lords. 10,000 to the wife and 5,000 to the child.
15,000 paid to the child.
My lords, I have already filed GNWC seeking custody of the child itself, my lords.
You want custody, but not the welfare.
And even my main prayer is before your lordship is to consider the application once again and by the family court and to permit me to defend the application. That is
I'm not convinced, Mr. Counsel. Take out notice.
Please, my lords.
Notice to the respondents, a hand summons on the counsel appearing for the respondent and file a memo to that effect. List the matter immediately after the memo is filed. Next.
Please, ma'am.
17.
Hearing for the petitioner.
Sivaram.
Yes.
In this matter, I'm representing the wife. This arises from an MC of the year 2023. I have filed an application for maintenance in 2024. After 1 year, 2 months.
Enhancement of maintenance.
My lord?
Enhancement.
No. The order has not been passed because of repeated adjournments by the respondent. Even after 1 year.
When did you file the IA?
8th of March 2024.
8th of March
2024.
2025. Which court is this?
This is 4th additional family judge. And I filed my affidavit of assets on 8th April 2024.
What is the relief? You're seeking mandamus?
We are seeking for a direction to dispose the matter within 4 weeks because the next date is 9th of July.
The writ petition is filed, seeking a direction to the court to dispose of the IA in a time-bound manner. It is submitted that the IA is filed on 8th March.
7th March, my lord. 7th March.
7th March 2024, and immediately the statement of assets and liabilities are filed by the petitioner. Whatsoever is the reason, it is so unfortunate that even after more than a year, the IA for interim maintenance is not disposed of. There is a report shall be placed before this court by the concerned judge why the application is not disposed of even after more than a year. The discharge judicial is directed to communicate. List this matter day after tomorrow.
Pledged.
Yes.
Cell number 18.
Appearing for the
Mohammed
petitioner.
Yes.
I need to produce the list of the amount paid by the
My lord, seeking
your lordship.
seeking
And,
direction to pay the arrears of the
I've already paid. I'll
5
produce
lakhs
the
is
entire
arrears,
list here.
5 lakhs is arrears, my lord. His daughter's marriage is nearing, that's what we requested.
As per my
This is
instructions, your
matter day
lordship.
after tomorrow. By that time, the arrears.
Monday, your lordship, Monday.
Where is the order?
Annexure.
On 1/8/2023, an order is passed, uh, whereby the impugned order is stayed on the condition that the petitioner shall continue to pay a sum of rupees 1,250
each.
to respondent number 1 and 1,250 to respondent number 2 per month. It is a contention of the land council for the respondent that the said order is not complied with.
I've complied, your lordship, because I'll produce.
Land council for the petitioner submits that the order is complied with. List this matter on Monday. By the time, if the amount is not paid, it is the stay granted by this court stands vacated, and it is open to the respondent to execute the order.
Obliged.
Cell number 9, Bindu you for petitioner.
Well, I appear for the petition, my lord.
What is, there is no video here? Yes, give the file. Just know it, ask him to come. Yes.
My lord,
Where is
what
the counsel?
Well, I am
Keshav? Yes, he was here yesterday.
Yes, no, this is serial number 19. Today only it is visible. That is
No,
different case.
Respondent Keshav Kumar B.
Well, he is appearing in the third case. He may be.
Yesterday he said that somebody has a
This is
representative.
in different matter, ma'am.
It's a different matter.
Different matter.
Where is he now? Keshav Kumar B.
Okay, sure. This is serial
This is
number
19, right?
Serial number 19, my
No,
lord.
there is a respondent advocate in the cause list. Have you not
Yes,
seen?
my lord.
Just today only it is listed. Yesterday's matter was something different, my lord.
So that I understand. I'm saying in this matter, counsel is not here.
Not here today. They are not representing the landlords. Even for
When this matter has come up before, that they have not represented.
notice has been ordered.
Learned counsel for the
advocate
petitioner
appealing for
seeks
the
time.
trial court.
It came up on 6/12. Learned counsel for the petitioner seeks time. Relist the matter in third week of January.
We are the petitioner, my
One
lord.
minute. Tag this petition along with so and so.
Yes, my lord. There are
And
three
now
matters.
nowhere it is never recorded that they were not represented.
Yes, my lords. In the first matter, they have filed the wakalat also, in fact, my lords.
Correct. That I'm saying this is coming up for the first time.
Interested in this, not interested in this matter, even in the before trial court also for my application.
No, to pass an order by this court that they are not pursuing the matter, at least on one occasion,
Yes.
there must be, there is no representation for them.
Please.
It has never come before the court after the wakalat is filed. We'll give them an opportunity.
Please, ma'am. Please.
Counsel for the petitioner is present, no representation for the respondent. List this matter tomorrow, no, not tomorrow, on Monday.
Cell number 20, Peter Devi MP for petitioner. Fatima SK for respondent.
First one is mine, is it? Yours? Yeah, it is. No, 4376 is yours. 14708 is first matter. Oh, this list is showing differently. Doesn't matter. But the two petitions which are before your lordships, my lord. First petition, that is 14708 of 2024, is filed by the father seeking enhancement of the modification of the visitation rights has been granted, my lord. The family court, my lord, as per Annexure A, has granted visitation rights only for from 9 a.m.
Please come to that order, page number.
Please, my lord. My lord, the operative portion is at page 47, ink page 47, internal page 25 of the impugned order, my lord.
Filed by the respondent or partly allowed.
The respondent is permitted 8 to 10, permitted to participate in school meetings without making any nuisance and affecting the future of the child. This is also partly challenged, my lord, partly allowed. Further, respondent is permitted to make video calls between 7 p.m. and 8 p.m. on alternate days. The respondent is permitted to take the interim custody.
So what is the modification he's seeking in this order?
Lord, there are two orders which we are challenged, my lord. Annexure A, the IA 8 and IA 10. IA 10, my lord, I had sought for visitation rights overnight from Friday evening till Sunday evening, my lord. Now the court has granted me only overnight. I also sought for 50% vacation.
Court has not granted you overnight.
No, my lord.
9 a.m. to 6 p.m. is granted.
And 50% of the holidays. I have the holidays. The child was with me for 1 month, for more than 4-5 weeks. He was there in the summer.
What is the age of the boy?
11, my lord.
What do you say on this?
We both were residing together. I have looked after the child.
This is a matter where the child, in fact, she voluntarily agreed at the time of hearing, even for the 50% summer vacations. As regards the overnight for the week, the father has extremely unhygienic habits. In fact, my lords, for 3 years, he quit his work and he stayed and just slept on the couch and taught all the wrong habits to the child.
Now, have you questioned this visitation granted by the court?
What?
Have you questioned the visitation that is granted by
That
the
is
court?
the morning to evening and the 50%? No, not at
You
all.
have not questioned.
Not at all.
So, as far as 50.
My petition is regards the maintenance.
No, 50% is concerned, is anyhow with the father, the whole.
That is the summer.
In the summer.
Yes.
So, now, when there is no difficulty for the entire summer for the mother, as far as this, every Sunday, what this order is passed, is what we can do is, let the father pick up the child on Friday and drop him back on Saturday.
May I just, even vacation, it is all right. Even though there is difficulty, she is okay. She will manage. Even the child does not have a bath for days together. That is what the father does. Does not have bath for weeks together.
My lord, I have objections.
Let me just. Very, very unhygienic way of living. And he has extremely high anger management issues. The question is whether in such a scenario, jeopardizing the child's.
But the difficulty is you have not questioned it. You are okay with it.
Well, from morning to evening, I'm okay.
But you are okay with 50% of the vacation. Where
That is because it's vacation.
No, but
We do not.
How does it matter?
In fact, I
Vacation or
myself am
otherwise?
submitting. It was a voluntary submission made that she is okay in the vacation. She does not want to.
Says for 50%, for example, he has 2 months vacation. For
Yes, my
30
lord.
days, boy is with the father, and for 30 continuous days, what happens? You are not bothered. But
Because it's
overnight in one day, what is going to happen?
Plus, it's not that I am not bothered,
And
but
then-
my intention is not to keep the child away from the
Correct.
father.
So why not the same principle here?
Plus, because it's school time and she does not want that to be disturbed. That is all. In fact, this is where, my lords, if your lordship recollect, this was in the chamber and I did propose. Yes, I did propose that all for plus twice in a month, even, if that is to be granted, then every week that would be too much, my lords. Not from Friday to Sunday evening will be.
I'm not saying Friday to
Because
Sunday.
where is the time for?
I'm saying Friday night to Saturday night, Saturday evening. Friday evening, picking up from the school and dropping him back on Saturday.
Sunday
Saturday
morning,
evening.
I'll drop my lord.
Not Sunday, not
Sunday
not
morning
2
I'll
nights
drop.
would be
Because
too
in
much.
Wendell, the whole weekend will go, because he's 11 years old, he also has to study. So what we do is Friday night to Saturday night, Saturday evening.
Friday evening, my lord.
Friday evening from the school to Saturday or
From the house.
From the house.
That will be
Friday
better because
evening,
she'll
5
finish the
o'clock,
homework and all that for
5
the child.
o'clock or 6 o'clock to Saturday evening 6 o'clock. Let him drop him back on Saturday. So that he has a overnight
At
custody.
least Sunday morning, I'll drop my lord.
Then in that case, it is Saturday night to Sunday evening. One day, because the mother also should have, and she is also working. The boy is aged 11 years. His requirements to be there.
Plus one more, can this arrangement, may I request the court to make twice in a month so that would be conducive for the mother also to concentrate on, because that
Let
now
them
the.
finish the homework. I'll pick up on Saturday and drop on Sunday.
Saturday evening to Sunday evening. All right.
Saturday evening,
I'm
Sunday
okay.
evening.
Yes, by then he will finish all the work and
But if the
assignments.
event there is a spillover, Monday or Thursday would be a holiday. Then what about
No,
those?
let's
No,
not
that-
go into
that-
all
let-
that. So, Saturday 6 o'clock to Sunday 6 o'clock. And the remaining things remains to be the same. Then coming to your,
Yes, my lord. Now a 20,000,
where is that order?
my lords, this is at page number
Give her writ petition.
134, my lords.
Yes.
Plus, it's at page 134. However, I would like to draw your lordship's attention to the affidavit of assets and liabilities filed by both the parties. Now, my lords, her salary is 1,16,250 which your lordship will find at 118 ink page, affidavit of assets and liabilities. And his assets and liabilities is at 124, relevant portion where he himself has declared his income will be, my lords, at page 127, 3,35,000. Plus all that I request the court.
How much is paying now?
Plus 20,000 is paid to the child. Mother does not want any maintenance. 20,000
What
is
about the educational expenses?
plus education. The court says 50%, whereas what I said in proportion to the income that is being, that is all I'm asking. Because he earns 3,35,000.
The other day she is submitting that he is not having the income at
Plus
all.
they're all, that, yes, that is recently. That in fact, my lords, they filed a memo recently, that was last date, that they
So
filed
from
an
when-
application before the court for reduction of.
No. When is the IA filed by you?
Plus IA file.
Date of the IA?
It's on 16/11/2022, my lord.
16/11/2022. When did he lose his job?
Plus 3/7, he is he, that document is filed very
He
recent.
has, there are periods where he did not have job. And because he's working as a consultant, from April to September of 2022, he did not have a job. Then he got the job.
Where is that?
23, April 2023 to September, he did not have a job. Then he
So
got,
when the IA is filed before the court,
he was drawing a salary of.
did he not mention all this before the
But
court?
we filed at that point of time what an assets and liabilities, as on that day, what was my salary, I have placed it on record, and that is 3 lakhs and odd. It is there. Thereafter, my lord, for a long period, he didn't have a job. Being a consultant, he gets the way, sometimes.
So
he doesn't
was
have
it
a
at
job.
least addressed during the
It
course
was
of
addressed
arguments?
during the arguments, it was addressed. And then he got a job of 3 lakh rupees from September 2023. That was a job was where he's working is now is Let's Dock. That's the company where he's working, and his salary is 3 lakh rupees at that point of time. It is now reduced. I have now placed it on record, my lord. The service agreement has been produced before this honorable court in my objections, my lord. I have
How
placed-
much he is getting now?
As on today, it is 75,000 rupees. I have produced from November, September, he said his salary.
Why the salary, why it is coming in the descending order?
Well, he is working as a consultant. It's a consolidated salary which they pay for a particular period. If there is a work for him, he is not a full-time employee. Service agreements are there which have placed it on record, and as per the agreement, the product which we're developing has been concluded. So he is paid for the work that he did at that time. He was working for 48 hours. Now it is reduced to 4 hours, 5 hours. So depending upon the number of hours that he worked is what they pay. I placed on record the salary statement, my lord, service agreement. I placed on record what is the salary. Now it is 75,000. Lord, what I would like to submit, my lord, the statement made by the council proportionate to her salary. Now I am drawing 75,000 rupees. She is drawing 1.5 lakh rupees. Then she should be paying more for the child than me. Lord, what does this now, my lord? When this change occurred, I had already filed my statement of objections. In my statement of objections, I have placed it on record. My salary has reduced. My salary slip has been produced. This honorable court directed me to file my bank statement. I have produced the bank statement. I have shown what is my current salary. Lord, also in this prayer in this petition, my lord, is that to take note of the changed circumstances and to modify the amount, to reduce the amount is what I have prayed for here. On the last occasion, my lord, I have filed a memo before this honorable court stating that changed circumstances, I have filed an
There is no
IA.
savings. When he is getting 3 lakh rupees, he has no savings.
My
Bank
lord,
account.
the savings, whatever savings, there are periods where he did not have a job. During that time, he has to fall back
All
on
those
that
bank
amount.
statements are before the court.
Beg
What
your
is
pardon?
outstanding in the bank statement? What is the
I
balance?
placed it on record, my lord.
How much it is?
As on. It is 2 lakhs. Huh? As on 15th February, it is 2,540,403. It's 25 lakhs 40,000. For 2 lakhs 54,000. 25 lakhs. 25 lakhs. 25 lakhs is outstanding amount that he has in his account.
Which
Based
page?
on that, Page number 19 of the bank statement.
Yes.
With the memo I have filed, it's filed on 24th February. This is the amount that he has. Based on that, he is now paying even that amount, my lord. Now the court has directed me to pay 20,000 to pay 50% of educational expenses, which I am paying.
How much is the 50% of the educational expense?
Comes to about,
It comes to about nearly 2 lakhs. That's it.
2 lakhs.
That's
So what is, no, 50% is 2 lakhs.
2 lakhs. That's it.
and I'm paying 2.5 lakh rupees.
And-
20,000 is 2.5 lakh rupees. My lord, 20,000.
Lakhs you are paying.
My lord,
Paying 2 lakhs.
my lord, educational expenses is 50%.
2 lakhs. And 20,000, that is 20
2
into
lakh
12
40,000.
is,
So 4.5 lakh rupees, whereas I am drawing only 75,000 rupees. It will be nearly 50% of my salary is going towards the child's maintenance.
No, not that it is constantly going to be 75,000 as it is.
No,
You have the savings of 25 lakhs.
There may I,
And also,
Sorry.
you will be, because as you say, it's a contractual something, that kind of a job. Not necessary that it will be static and everything, you will be receiving only 70. Even when you are having 3 lakh rupees also, you are paying that whatever, now the entire amount what you are paying is one month's salary of yours when you are having 3 lakh rupees.
So at that time, I never even challenged that, my lord. Whatever has to pay. My lord, now that 20,000 rupees was for her to take care of all the other expenses. She now files for abacus class, this class, that class, whatever she files, I have also paid that amount.
Is it so?
Plus,
Above
above 20,000
above
rupees.
and all, he is paying all the.
Milords, that's not true. I can ascertain and submit that's not the truth. Milords, may I just point out the memo filed by them itself, where he has produced the latest service agreement, where it says 3 lakhs. That
No.
where?
Which year, which date? What
In
is the
this
date?
case, 13/12/2024.
13?
No, service agreement 1/8/2024.
13/12/2024, they file a memo in 4376.
4376.
13/12/2024. Annexure R1, Milords.
Yes.
Last page, page number 16. He says he's drawing 3 lakh. That is at consideration, Milords. Below the consideration. That's page 16.
I think that's not here.
Milords, they filed a memo with documents, that is statement of objections filed by the respondent.
Statement of objection.
13/12/2024.
13/12, yes.
I'm sorry, Milords.
Yes.
Page number 16. 3 lakh he is drawing.
To get that.
Milords, below
16 page
consideration.
says applicable law and jurisdiction.
Milords, this is a document, annexure R1.
No, there is a document, service agreement.
Yes, they have
In
numbered
that
it
service
as,
agreement, what is the subheading?
Milords, it's given as service agreement, yes.
No,
Yes.
you are referring to a page.
Referring
The
to
salary
page
and all
16 is
that.
what they have numbered here, 16, Milords.
16, what I can see in 16 is, it starts with which is expressly or by implication.
No, Milords, that I think they have probably.
There's something wrong with the pagination.
Milords, it's a consideration under the head consideration.
Under the head of consideration.
Yes.
Yes.
Sum of 3 lakh is mentioned,
It's
Milords.
page number 13 is a consideration.
13, probably they have not.
Project will be performed on a firm fixed price
Correct, yes, Milords.
basis.
Please.
INR, so the
3 lakh.
supplier is required to work for 48 hours per week.
Correct. Even as of, Milords,
This is
even
dated.
dated 23, it's all right. Because nowhere in this
1/9/2023.
I'll just submit. Nowhere in this agreement, it says it will be for just 1 year or this sum is just for 1 year. Because it's a startup. In fact, I have material to show that its own relative that is involved in this startup company. Definitely there is chances of diverting the funds and it's going on reducing from 3 lakh to now 75. Then I think tomorrow he will say I'm earning 50 and then he will say, no, I've lost the job, I can't, and he will sit on the couch. This is the way they have.
My lord, I have 3 points for submission, my lord. First of all, my lord, I have never shirked my responsibility towards the child. I am willing to take care of 100% whatever is to take care of the child. That is a submission I had made earlier also. Even now, I'm making that submission. If she hands over the child, everything I take care of the child. Last occasion, I made a submission whether we can share 50-50. That also they were not agreeable. Now, my lord, she moves the child. The child was studying in Frank Anthony Public School. She moves from here to an elite school, which is now charging 3 times more than what the school was this earlier school was paying. I was paying entire fees for that school. Even now, I commit that if Frank Anthony Public, whatever is the fees, I pay the entire amount fees. And now, my lord, I'm submitting 50% as towards my child. I'm willing to pay that amount. I'm willing, even in Frank Anthony Public, I'm willing to pay. I'm not against my child or wanting to pay anything for my child for his needs. Now, my lord, if I stop there, that I'm willing to do that. Now, my job is flexible, which she is aware. 3 years, I did not have a job. Then I took up a consultation job because when I moved from a regular jobs and 3 years when I sit back, why did I sit back, my lord? That she had to go to job. If she goes to work, somebody has to sit back. I became the home husband. She was going to work. And then I banked upon my savings to take care of the home expenses, everything. A house is his own, his parents. He's staying independently from his parents. They stay in the same complex. Parents are staying independently. He's the only child and they were staying on their own. Now, whatever expenses was 20,000 rupees. In my statement of objections before the family court, I've said entire maintenance for the home for us was 20,000 rupees only. We did not have an affluent lifestyle. We do not belong to that kind of the homes. That's not the way we lived also. And the house is also an MIG type of home that we are staying. That is a statement we have filed on record, which is not disputed by them. Now, my lord, when I have this salary of 3.5, I was paying that amount. In addition to that, they say that we have not paid. In my objections, I've said over and above that, every payment that has to be paid, I have paid. It's not that I have not paid. They file on record, screenshot paid to XYZ. We don't know who they are. That is also produced before this honorable court. In my writ petition, I have produced at page number 78. I have also filed a memo where they say chess fees, cricket, uniform, whatever has been filed. Though I have disputed that it should have included in the 20,000 rupees, it should have been included, but yet I was willing to pay there because under protest I have paid. It can be calculated, whatever. So one, we have to see that, my lord, what is the amount of maintenance that I have today. I have filed an application, my lord. May I just, it is true, my lord, by mistake, I have filed the service agreement or in my statement of objection of month of 2023, August 2023. In a memo filed on the last occasion, that is on 19th June 2025, I have filed a memo. In this memo, my lord, I have placed on record that I have filed an application before the family court to consider my application for changed circumstances, whatever is my salary, my lord. This matter has to be considered by the family court. My IA is pending there for modification with the changed circumstances. Ilva. The lordship could find it, my lord?
Yes.
On 16/1/2025, my lord, after I could not file a writ petition here.
This is the same company which has given 23 and which has given now also.
2024, yes, my lord. I'm in the same company, my lord. If I get a better job, I'll move out, my lord. If I get a better job, I will move out. But in the current scenario where we have even to hold on to a particular job, even if it is granting me.
Even in the current scenario also, with all the reserves you have, I think you can take care of the child. Whatever now, this order, whatever the court has passed, let it go on till your application for modification is considered by the court.
Very well.
Plus, may I just take your lordships to the bank statement where 70 lakh is the balance and he earns interest itself lakhs together every month in their own bank statements. Every year he's been paying the legal fees. I do not want to say running into lakhs together. After all, a matter of 1.5 lakh, 1.25 lakhs is all that I'm asking for education expenses, not anything else, my lords. That is all I'm asking. In fact, let there be to that extent, after that is decided, my lords, whatever the court decides, whoever is agreed will be.
Whatever the order will confirm it in the sense because pending application.
Plus only educational expenses, I would prevail upon your lordship because she has also, I have made sure.
The court has granted 50%.
My lords,
50% is already granted.
Because she is 1,16,000 is her income. Here, my lords, in the statement itself, forget the salary, my lords, in the statement, lakhs together he gets as.
That's the reason why, because court is looking at it, though they say now it is 75,000 is the salary.
Correct.
Still the court is not interfering at this stage. Court is not interfering with that.
In fact, my lords, this application is filed even after my writ petition, knowing that I have preferred here. They filed an application on 10/6, not 10/6, on 16/1/2025 before the
trial court,
When is
knowing
the-
completely
when-
well that I have filed here.
When is the impugned order?
Plus impugned order is on, see, 10/11/2023. 2023, my lord.
15/12?
12/2023.
15/12/2023. When is the writ petition filed?
15/12, no, my lord, please, my lord, that is the order, impugned order is 15/12. It was filed on, in the 2nd February 2024.
When is your modification application?
I filed in January because the change happened only in the, he brought it to my notice in this time and the arguments were going on in this matter. I did not file a writ petition here again because it means that the court has to consider the matter. After 1.5 years, I can't file the challenge that order. Change circumstances, I placed it before the family court. I only appeal to you.
But change circumstances, it is not something that one will forget. He is supposed to
I'm
bring
paying
it to
that
the
amount.
notice of the court.
No, I'm paying that amount as on today also. I'm paying the amount. I have not reduced my payments, whatever has to be done. Out of the 75%, 75,000 I'm earning, my lord, even after post deduction, I'm getting 67,000 and odd. More than 50% is going towards the child. I'm paying that amount. I'm only appealing to this honorable court. Let the family court consider the application. Whatever has to be.
That is a
These
subsequent
two matters for
application.
judgment. Tomorrow I'll dictate the order
Very well.
for judgment tomorrow.
It's my lord's permission. Serial number 21, my lord.
Yes.
We refer to mediation. It's going to be set.
It is submitted that by both the council that the matter may be
I'm
referred to the
respond.
Bangalore Mediation Center. Party shall appear before the Bangalore Mediation Center on 8th of July.
My lord,
Next, 22.
item number 20.
But I have a judgment to be placed, my lord.
Please, my lord.
Tomorrow you can. Tomorrow you can. Yes, 22.
My lord,
In 21 interim.
I will be calling each number.
number.
Then you can. The 21 interim order earlier granted is extended. 22.
22, my lords, we have engaged senior counsel in this matter, my lord. He is fleet in NCLT, is stuck there today. Kindly have it on 30th or 1st of this
You
month.
offer the petitioner.
Yes, my lords.
Is this matter at the request of the petitioner on
30th or 1st of this month.
First interim order earlier granted is extended till then, if at all, look at it. Then 23.
23, Sudesh Kumar
The
Acharya.
respondent. In this matter, the matter is already settled, my lord. Therefore, I have the respondent husband has withdrawn 2 petitions. This matter is for withdrawal of.
Where memo is filed.
No.
The other
Then
side has not filed.
23 lists the matter tomorrow, let the council. No, but Prasanna VR is at
Yes,
there.
madam.
Yes, tomorrow.
Number 24.
Your lordship, I haven't received the objections copy, the petitions.
It's already filed in the court.
I haven't received the
No,
copy.
you have to give a copy of it to them.
As well was submitted and was handed over
No, your lordship.
Whom you have handed over?
to the court itself. The entire filing was done in the court.
How can it be done in the court? You have to serve a copy on the council. Then only you can. Otherwise, without notice, what will they will do?
I'm not sure about the objections, my lord. I was asked to submit the entire file set.
Whatever you are submitting, they need to have a copy
That
of
has
it.
been given in the court itself. I've given it to the other side.
No, your lordship, it hasn't been served to us.
The other person who was
The party in
representing-
person shall serve the objections that are filed to the council for the petitioner. List this matter on,
Your lordship, it is already signed by the council who was present in the.
can you
copy
please
that I've
look at
submitted.
it? Look at it.
When was it served? It was submitted on 16th.
If it is
April.
signed, court will view it very seriously. Look at it. Their objections are signed by the advocate. Show it to her.
16th of April.
This one.
Yes.
Give it to her. Yes, counsel? Bottom, there is a signature.
It's not, it's our cases. Yes, it's served. Apologies, your lordship.
It's not right. Already she's a party in person. She is not aware of all this. You should be cautious before
Your
making this
lordship,
kind of
because there was a
submissions.
submission yesterday made in the court that the matter is on stay and the matter is not on stay. She is taking time from last 3 dates.
No, that is not, we are only on the point that the papers are served and you said it is not served.
Apologies,
List
your
this
lordship.
matter.
Lordship,
On-
I have never
on
mentioned
third.
anything in the court. That was mentioned. from-
Yes, this is matter on third. Yes, next.
Till number
25.
25. Mohanji, J.R. Mohan.
Petitioner.
Yes.
Matter regarding the attachment of the property has been ordered to be attached under order 38 would will find.
For the respondent. in
So
this.
now the matter is again set out for evidence of the plaintiff. This is the defendant's writ petition one. Now, the property belongs to the wife. And there
Any
is a-
interim order is there in
Next week,
this?
any day. I sought for interim order to stay the order of that attachment.
This is matter on
Because it's a
8th
fresh
of-
it is a fresh matter.
8th of
actually.
July.
I don't know how it has come in B group. It is a fresh matter.
You should list it in preliminary hearing
Next week, any date.
next week.
8 July. Serial
Yes,
number
26.
26. Nagesh Vinay.
26, my lord.
Appear for
I want to
petitioner.
file my objections, my lord. They have served the copy. I have to file objections in one of the persons.
My lord, we are seeking for interim stay, my lord, because it was moved in
We can't
vacation.
be done, my lord. Visitation right. They want to take away the child outside Bangalore. I have filed the petition, they can't.
Senior
I have the
counsel,
visitation rights.
he is a petitioner. He has every right to submit. Let the court hear him, then you can submit. Yes.
My lord, the impugned order is at page number 44, my lord. I am seeking stay of only portion of interim order, my lord.
Yes, which page number?
In writ petition 14503,
Huh.
page number 44, my lord.
40?
4. Internal page 25, running page 44, my lord.
What is the order?
My lord, husband has filed GNWC petition seeking custody of the minor child, my lord.
You are for the?
Wife, respondent wife.
Hmm.
Now we are seeking stay of the portion of interim order that is last but second paragraph, my lord. Petitioner has the right of contact with the minor child on alternative days through video calls for a period of 1 hour in between 5 p.m. to 7 p.m. with prior intimation to the respondent. Now this is causing great hardship, my lord, because child is aged about 2 years, 9 months, my lord. It has become very difficult to sit the child for entire hour to facilitate video call for the respondent husband, my lord. I have placed all the email charts, my lord. It is causing very much difficult, my lord, because child, he has learned how to operate the mobile phones, my lord. He is cutting the phone accidentally. There is no point in facilitating video call for entire
The
1
other
hour.
portion of the order, you are complying with it.
Please, my lord, we are complying, my lord. But we have challenged that order because every Saturday and Sunday visitation is granted to the father, my lord. Every Sunday, weekend, that is Saturday and Sunday, from 2 p.m. to 6 p.m., my lord. We are seeking challenge that order as well. But in the meantime, we are seeking stay of only portion of this order, my lord. We are ready to facilitate physical visitation for the husband, my lord.
Yes, yes, senior counsel.
Child is suffering from kidney problem. Every day he has to be looked into. My lord, the moment it is every day medicine has to be given. He is being treated in Bangalore in a specialized hospital. That child is suffering from birth. So my lord, the father has come back from America and he is taking care of the child. All that I want is, my lord, I want to take care of the child. He can't take away. I have to look into everyday affair. Every day I have to take care of the child. So 2 to 5 my lord, visitation rights is given. I have to talk to the child and
Senior counsel, they are not questioning the other part of the order that is granted by the court. They are okay with the visitation. What they are saying is, please understand, what they are asking is the last portion of the order. Petitioner has a right of contact with the minor child on alternative days through video call for a period of 1 hour in between 5 p.m. to 7 p.m.
Yes,
What
my
they're
lord.
what they're saying is the boy is too young. He's not able to manage with that call, and he's time and again he's disconnecting the call, and it's difficult for the mother to comply with that. To that
My lord,
extent, they're saying.
my lord, there is one more petition which I have filed. In that manner, we said that child should not be removed from Bangalore. What the order that has been passed by the court is, he can take anywhere in Karnataka. That also we have challenged before this court. If the child is taken away from Bangalore, where can I contact? Where can I have the visitation right? When can I meet the child? Child is suffering from.
I'll hear both the matters tomorrow. Mrs. matters tomorrow.
Please, madam. Kindly be taken up on preliminary hearing, my lord. It is a fresh matter.
List these two. Why they are listed for this caption when there are fresh matters? Do that.
All three
Tell
are
them
fresh matters.
all these matters, 26 shall come in admission matters. Yes, for preliminary hearing.
sitting only referring to matters. ಇಲ್ಲ ಯಾವತ್ತೂ ಇಲ್ಲ ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಲೋಕದಲ್ಲಕ್ಕೆ ಹೌದು ಸರ್ ಎಲ್ಲ ಮ್ಯಾಟ್ರು ರೆಫರ್ ಆಗಿದೆ ಲೋಕದಲ್ಲಕ್ಕೆ ಡೇಟ್ ಎಲ್ಲ
ನಾನು ಅದನ್ನ ನೋಡ್ದಲ್ಲ
ಕೊಟ್ಟೋದ್ರೆ ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲಪ್ಪ
ಸಪ್ರೇಟ್ ಲಾಗ್
ನಮ್ಗೆ ಅದು ಮಾಡಕ್ಕೆ ನೀವು ಅಲ್ಲಿ ಕನೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಅದೇ ಕಂಪ್ಯೂಟರ್ ಐ ವಿಲ್ ಆಪರೇಟ್ ಇಂಟರ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂತ ಎರಡರಲ್ಲೂ ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ ಇಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಅಂತ ಕಾಣುತ್ತೆ ನಮ್ಗೆ ನಾವ್ ಅದನ್ನ ಸೆಪರೇಟ್ ಮಾಡ್ಬೋದು ಈಗ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ ಮೇಡಮ್ ಹೇಳೋ ನಮ್ಗೆ ನೋಟಿಸ್ ನಾವೇನು ಕೈ ಕೊಡ್ತಾ ಇರ್ತೀವಿ ನಮ್ಗೆ ಅದು ನೋಟಿಸ್ ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ
ಅದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆದ್ರು ಅದು ಇದು
ಅಲ್ಲಲ್ಲ ಲೈವ್ ಹೋಗುತ್ತೆ
ಸದಾನಂದ ಅವ್ರು ಹೇಳಿದ್ರು ಮೇಡಮ್ ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ನಾಳೆ ಇರೋದೆಲ್ಲ ಇದೆ ತಗೊಂಡೋಗಿ ಕೊಡ್ಬೇಕು